Hey, everybody. Good morning, good afternoon, good evening, good night, wherever you are, whatever you're doing, whoever you're doing it with, and whyever you're doing it. I hope you're having fun. Welcome. It's me, Legal Vices. We are here on the channel Legal Vices. We've got a quick show to do today. We've only got 90 minutes left because the wonderful, amazing, interesting, and captivating Murdoch trial will be starting in 90 minutes. And everybody's going to jump over to Joe. And just right off the bat, well, we'll give you the right off the bat in a little bit once you give YouTube their little buffer before you can say cursey words and sweary things. We'll do that in a bit. Right now, just got some quick background stuff to take care of. One of our guests, Dani Ahn, is not here yet. Utah is is being buried under a massive blizzard. Internet is out. She says she's trying to connect and will be here as soon as possible. We've got our like and subscribe poll up. And right now we are very, 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 very close to a good number of subscribers. Where are we? Come on, phone. We are at 33,799 subscribers. One more and we're at 33,800. 200 more and we're at 34,000. Woo! All right, so make sure you hit that like button, hit that subscribe button. Today's like and subscribe poll. It's kind of hard to make fun of the stuff that we're talking about today, so we just made it a fairly straight yet slightly irreverent like and subscribe thing. Did you hit the like and subscribe? Did you hit the like button and make sure you're subscribed? Yes, I always do. No, well, yes, because you just mentioned it. Yes, I cheated, but I repented and did it. And yes, God, stop talking about it. Those are the choices we've got today. And let's see. Running through that again. Super chats, the rule is the same. The rule is the same there as always. Not required. No minimum mandatory to grace me with your presence or to summon me. You just put down that super chat summoning sign and I will respond. I will answer. Every super chat is you parting with some amount of your hard-earned money and throwing it at me for some reason I'll never figure out. So I respect everyone in the super chats. Even those who don't super chat, I address as many as I can as we go along, but chat moves fast. Don't want to get too derailed by the chats, but the ones that I pick up on, the ones that I get, we address those as well. And I have the greatest chat on the entire internet. So sorry to all my guests and all the other channels, but the Vice Squad rules. There we go. That's it. We got a lot of ground to cover, and we've gotten enough. We've gotten enough of our little buffer here. We're 3.5 minutes into it, so now I can say it. Don't fucking bring drama to my channel today. This is not a drama stream. We're talking about some very, very important issues. If you have drama with Farron or whoever the fuck else you've got, take it to their channel. I have guests on my channel. Do not come into my house and shit on my guests. I'm not going to put up with this shit. Anybody that knows me knows that I do not ban people. I'm done with that. There's so much shit and negativity going on there that I'm done with it. Nobody's shitting on guests. You get the ban hammer for the day. I'll go back after and release the Kraken again tomorrow, but I will not put up with this shit today. Respect me, respect my channel. As I respect you and your views. Just if you have drama with someone, take it to their home. Don't bring it in my living room and shit on my carpet. The end. Let's get on with our show. Dani is desperately trying to connect with her phone. Dani Ahn will be here when she can, if she can. The great blizzard of 2003 is sweeping across Utah. Let me see. I'm checking. I'm bringing up the last messages. Yep, I'm trying to connect my phone hotspot. So whatever she works at, if she gets here, she gets here. If she doesn't, she doesn't. If she gets on and off and on and off and on and off, we'll deal with that as well. But what in the hell was that? All right, let's bring up our guest of the day who is here and backstage. It is the one I just removed. There we go. Megan Fox.
Hi.
It's like the wrong button. How are you doing this morning?
I'm wonderful. Thank you. How are you?
I'm great now. I got the adrenaline going. I'm in a mood.
I'm in a mood too. Hey, don't send them to my channel. I ban them too. I'm all day long.
As long as it doesn't happen on my channel, I don't care where it happens. I invite guests because they're important, they're topical, they have things that I want to talk about. And if you don't like it, you can just fuck right off and go to a different channel and come
Fuck
back.
right off. That's exactly it.
And you be adults. All right, and we've got 2 super chats to clear through here right out of the gate. From earlier, Jason J says, dirty, corrupt cops and judges do need to be physically punished. Minimum 15 strikes with a rattan cane, just like Singapore changed my mind.
Yep. No,
Well,
I'm so with that.
Today. Yeah, we're going to be talking today about a judge who also thinks he's a cop. So give him 30. That's what I say.
Yep.
And Chaos Coordinator. Legal Vices in chat is the best on YouTube. If you have any problem with it, then get the fuck out, or I'm going to start biting like German shepherds. And Chaos Coordinator is sick right now, so you don't know what you'll pick up from that. So, all right, this is a thing that Megan tipped me off to the other day. Suddenly there was just this big flood of tweets coming down about this topic, and I was watching the little clips, going, "Well, that's weird. Well, that sucks. Well, that's very strange." Well, I think we need to talk about this. So then I got you, and this is a project you've been working on for years.
Mm-hmm. Yeah, years. I've been studying and researching, investigating Missouri family court corruption for years, and I spent
Why Missouri?
Well, it all started with Evita Tolu. She's an attorney who contacted me because she was suing guardians ad litem and psychologists, court-appointed psychologists in the St. Louis court system for what she said was a shakedown. Like, they basically took hundreds of thousands of dollars from her and gave her children to their father, who she says abused them. And she has a lot of records, including police records, to back that up. And her lawsuit caused 31 judges on the St. Louis Circuit Court to recuse themselves from her case. That's what kicked off my entire, there was a leaked Zoom call of all the guardians ad litem plotting together with judges. The judges weren't on the call, but they were in their emails, and they were talking about the judge, the Chief Justice of the Circuit Court, like plotting against a litigant in his court. So they all had to recuse themselves. The entire court had to recuse themselves from her lawsuit. So it turns out, through my investigation of that lawsuit and all the different victims that Evita Tolu had found, I have binders and binders and drawers full of these people who have been trying to get justice in St. Louis. Well, one day I get a call from a man who has 2 children who were in America's Got Talent, the Rocket Children. And he says, I know you're covering Missouri. I have a 27-part series on Missouri family court corruption. That's how many that I've got. And you're muted.
Wow, I've been talking all to.
You've been talking?
I've been talking. Yeah.
I didn't hear you because you were muted, you boomer.
Andrew, see, Jeff is a loser. That's okay. Shit on me. Don't shit on my guests. You don't get banned for shitting on me.
That's so funny. No, the Missouri.
Anyway, what we forgot to do is we forgot to introduce you.
Oh.
First of all, this is Megan Fox, not the thumbs. This is the medium smart one.
Right. Medium smart.
Megan's
investigative journalist.
Give us the 30-second. Who is Megan Fox, not the thumbs?
Sure. I'm a journalist. I write with pjmedia.com. I am an author. I've written 2 books. One is called Believe Evidence: The Death of Due Process from Salome to #MeToo. You can pick it up on Amazon. Or Shut Up: The Bizarre War That One Public Library Waged Against the First Amendment, which is particularly timely for today's fight with board members and boards all over the place, shitting on parents' rights. So that's a good one to pick up. But
this is a scatology show here. This is a scat show today. There's going to be a lot of shitting going on. There's going to be a lot of shitting going on today. Sorry, continue.
But people contact me because I have written about CPS corruption and family court corruption for about 10 years. This Missouri story, though, is the biggest one that I've ever encountered, the biggest, deepest hole. And I always say Missouri is like the doorway to hell when it comes to family court corruption. And it's because it's a never-ending rabbit hole. The more rabbit holes you go down, the more there are. And so I got this call from Bart Rocket, whose children were in America's Got Talent.
Mhm.
They're an entertainment family. The children were raised in Branson, Missouri, doing a family magic show with their mother and father. And when mom and dad got divorced, things got ugly. Mom decided to leave entertainment and move to Utah, and she wanted the children to leave entertainment too. So what happened was she was fighting in a Missouri court. She filed in Missouri, even though she moved to Utah. She filed in a Missouri court, and they ended up with Judge Eric Amy, and that's Eighmy. Strange spelling, but you say it Amy.
Now, when you started uploading all this just recently, I wasn't aware that you'd done a bajillion things, not only on this case, but also on other parts of Missouri corruption.
Oh God,
And
it's huge.
we've got, Chica 422 says, "Wow, I had no idea, and I live here in Missouri."
Stay out of family
strap
court.
in. Just
And
strap yourself in.
Stay the fuck out of family court, okay? Don't
Yeah.
get divorced. Or if you do, make sure that you guys have an agreement and you go in agreeing from the beginning, because it is one of the worst places on earth for family court issues.
And so what I did is I got that bit of background from you, and then I read the couple of articles you sent me, and then I went and got the actual lawsuit that the father filed against a judge. And but first I read the appellate court arguments. We'll get to we're going to wrap this up with the appellate court argument, like we did with Steve Gosney and his appeals. But this is just an audio, and it's a little different than the Gosman's appellate arguments. And I listened to that, and I thought, wow, this is just an absolute crap fest.
Oh,
And
total shit
then
show.
I read the complaint, the civil complaint that the father filed against the judge, and went, holy crap.
Oh, it's bad.
This is way bad.
It may be the worst thing we've ever caught a judge doing, and thank God he had the resources. Bart Rocket had the resources to sue. And now, what they're fighting is right now they're still fighting on the motion to dismiss. The motion to dismiss from Amy's lawyers, who, by the way, are the Attorney General's flying monkeys. The Attorney General of the state is defending this man with taxpayer money, which is disgusting, because what he did was take these children. So this is the thing that kills me. Mom and dad had an agreement when they came out of court one day, and the agreement was that the children were going to live primarily with her. So dad agreed they were going to live primarily with her in Utah. They come out of the courtroom, kids are in the hallway. Dad says to the kids,
I'm going to push pause right there.
Yeah.
Let's use this as the springboard to go and read the complaint.
Okay.
So we don't go back over this thing. This is all laid out here, and we can provide our comments as we go through. Now, mind you, this is all just to kind of go to the final chapter before we do a time jump back. Right now, this is in the appellate court because they sued a judge, and you just don't sue judges. Judges typically have judicial immunity, which means you just can't sue somebody because you don't like the way they decided their case. There's only a very, very limited set of circumstances where you can file a lawsuit against a judge.
Mm-hmm.
So
this is one of them.
This guy filed his lawsuit against the judge. The judge went and appealed. He went for a dismissal, and he got shot down. And now he's appealing the dismissal of his attempt to get this case thrown out on the grounds of judicial immunity.
Mm-hmm.
And that's where we're gonna end up today. But right now, let's bring up the actual complaint and hit the highlights. Let's see. Winder, bring up the Winder. Do.
If you hear something screaming in the background, that's just my rooster. He's going nuts right now.
And if you hear something that's like, that's two English bulldogs underneath me attempting to breathe. All right. I guess this is about as big as we're gonna get it. That's what she said. I think we can go one more ish.
This is a great lawsuit, by the way. I mean, it makes me so proud when people file these suits, and follow through with it. And it's hard though. You have to have a budget to do it. That's why hardly anybody can, because family court robs them of everything they have to begin with. And then there's nothing left to go after the people who robbed them.
Oh, and before we get going, I do have to do my my daily grift with the Dragon's Treasure tea. The Dragon's Treasure at thedragonstreasure.com. Some of the most amazing tea you'll ever have in your life. Every month there's up to 60 loose leaf and bag teas, depending how you like it. Tonight we're having the Earth Kingdom almond oolong tea. It's nice and strong and earthy flavored. It's absolutely amazing. But go to the Dragon's Treasure, pick it up, buy some of the most amazing tea you're going to do, and use code VICES, get 10% off. You get 10% off. I get 5% kickback. He gets a sale. So it's a win-win-win. Just shut up and do it. As the Dragon's Treasure says, you buy it, you buy it. Exactly. That's exactly what's going to happen. So we're having our tea while we spill.
Buy it or the cat gets it. Remember?
All righty. So let's get into this thing here. D. Bart Rocket is the father. He's we'll go through all this. Don't want to repeat too much. Okay, BR and KR are minors. There is children. He is a magician and performer, and he was the proprietor of a theater in Branson, Missouri. So they have this court date. This is what Megan was talking about. They've got this court date where they're going to try to modify their custody battle that has been going on for like more than a decade. All right. So BR and KR stated firmly that, and how old are they? These are like 13?
At the time, 12, I believe 12 and 14.
Okay. So they're 13 and 15 now. They were 12 and 14 at this point in time. And my dealings with family court and people I know, that is well into the age where judges will ask children what their feelings are about custody arrangements.
Most of the time. In Missouri, not so much, but in normal cases, like in normal courts, the judge will give.
Spoiler alert! It doesn't.
Spoiler alert! Doesn't happen in Missouri. Missouri judges really think they rule the world.
So this is the TLDR here. So they have a court date to discuss a modification to a custody agreement. BR and KR stated firmly they do not want to leave with their mother. Judge Amy, acting in a police function without judicial process or immunity, personally jailed the children for approximately 1 hour. Mm-hmm. He made no findings of contempt, delinquency, or probable cause. Judge Amy later issued pickup orders for the children, and they were jailed for 2 nights in Louisiana. And just in time, here is, by as remote as you can possibly get, Dani Ahn.
Hey, everybody. I am so sorry. I have my camera off because I'm not entirely sure that my internet will sustain itself if I turn on the camera. But I wanted to hop in and just say, Megan, I am so grateful that you are uncovering this, that you are delving into this.
Thank you.
Quick introduction. I'm a family law attorney practicing in Utah. I help people get divorces all day long. This is my bread and butter. What is odd, though, is I was also a young performer in Branson, Missouri. At the age of about 14 or 15, we moved out there. My dad took off, and my parents had some disputes in family court in Missouri, and it was, in fact, a joke. So I am very intrigued by this case, and I can't wait to continue listening.
Oh, well, Dani.
I wonder which theater the Rockets purchased.
I told you, Dani, that this was the case on planet Earth that was made for you. Are you aware of the Rocket family?
I am aware of the Rocket family. Now, do I know them as well as like the Duttons and the other family performers? No, but I can tell you right now, this is not the first. That's all I have to say. This is definitely like one of millions, I'm sure.
Wow. Oh, yeah. Look, Dani, I've got drawers full of Missouri families who have been dragged through absolute hell. And in fact, Jeff will put me in touch with you. I'll get your email.
Yes,
I'll send you a link.
Need to hook up.
I will send you a link to my Missouri Family Court Corruption 27-part series. Your mind will be blown.
I would love to read it. And family court in particular is very ripe for this type of corruption and this type of judicial overreach. We see it out here in Utah, but we have a commissioner system.
Mhm.
And so generally our commissioners, you can appeal the decision of the commissioner. And as a matter of fact, I've had commissioners look me in the eye and say, I'm not entirely sure I'm making the right decision here. You're welcome to appeal it to a judge.
Mm.
Now the judge will take a second look. Doesn't mean they always do. And I have won 2 appeals court cases here in the state of Utah in family law, because the judge just was very biased and ended up siding with the other attorney just because of his relationship with the other attorney. And it was bad. So I've seen it happen. I know it can happen. And Jeff, you're absolutely right. At 15 and 13, the court should be asking what the preferences of the minor children are, not for the 13-year-old, but for the 15-year-old. And then generally family law courts like to keep kids together. So if the 15-year-old is saying, I want to go live with dad or mom, the 13-year-old is likely to follow. So there we go.
So basically, I insisted that Dani be here for this because talking about this case is all about a divorced family with a mother who will learn more about living in Utah, child performers in Branson, Missouri, family law, all this stuff. This is a case that Dani Ahn was made to cover. And I think that Megan, you and Dani need to definitely get together and talk more later about.
Oh, for sure. I also want to
Absolutely.
point out, it's important for everyone to realize that the mother raised these children in entertainment. So she was gung-ho in the entertainment with the children and her husband until the divorce, when suddenly entertainment became the devil. So that's a good point to remember, because some people are like, well, kids shouldn't be in entertainment. It's like, wait a minute, this is an entertainment family. Okay, these kids were raised on a stage. Remember that.
So did you read the complaint, Dani?
I have not had the opportunity to read it yet.
Strap yourself in.
Strap in.
We're going for a ride.
To Megan's point, for those who are wondering, like, I was a young performer in Branson, Missouri. I was fortunate enough to do some of the openings for many of the theaters. I know many of the families down there. And I will tell you, these kids love their work. They're professionals. They wake up early in the morning at 4 a.m.
Yep.
They rehearse all day. They perform in the evenings, and then they have their homework and their home study that they do backstage all day long. And this is their life. I could not imagine my mother trying to pull me away from my career when I've already invested as much as I have into it. I would be devastated.
Well, watch this. You're going to see what happens when when you try to do this. Before we go, the Allen gifted 5 Legal Vices memberships, and it's Allen's birthday today. Maud Allen, happy birthday to you, and thank you so much for the gifted memberships. And we have our final outstanding super chat so far. Nicholas Starr of Union Rep Labor Law says, U.S. internet is bad. My mobile broadband gave me 200 out of 200 unlimited, and I pay $35 a month. I love Korean internet and phone service. Everything is cheap and unlimited. So we got the parties here. They're minor children, now age 15 and 13, respectively. This was last year, I believe. So anyway, they're teenagers. They're public figures in the entertainment industry. Plaintiff has sole custody. This is the father. He has sole custody now. His name is Bart. KR, BR, and Bart have been residents of Union Parish, Louisiana since spring 2020. Other relevant times, they lived in Los Angeles. This is a civil rights action pursuant to the 1st, 4th, and 14th Amendments to the United States Constitution. Now, they're saying that everything that the judge is the defendant here. And as I said, you do not file lawsuits against judges. And if you do, they almost immediately get dismissed due to judicial immunity. This one isn't getting dismissed yet. And so they're saying that the defendant, he acted under color of law, statute, ordinances, regulations, policies, customs, and usages of the state of Missouri. And the plaintiff is demanding a jury trial. How many people in Missouri want to get their hands on a Missouri family court judge?
So many. So many. I would love to watch the jury picking of this trial. God, I hope it goes to trial.
Oh, I hope it does too. Oh, and for everyone who was listening in, I heard you mention PGAL. for those who don't know and who aren't in family court, they may not know what that is. That is an sometimes appointed guardian ad litem. And what they do is they represent the interest of the child. So when you have a attorney or a representative representing the interests of the minor children colluding with the judge on custody decisions, that's a big no-no and a big issue, because the judge, and even out here, the judge and commissioner weigh their opinion very heavily in making their determinations.
Mm-hmm.
And Alan has just gifted 5 more Legal Vices memberships. Thank you again, Alan. So as Megan was saying at the beginning here, everything was all hunky-dory, happy, peace, love, flowers, roses, macaroni and cheese, and whatever else before 2009. Bart and his former wife, Cammie Lynn Rocket, lived in Branson, Missouri, where Bart operated a theater and was a well-known entertainer. Bart and Cammie are the parents. They divorced in August 31, 2009, and then everything went to hell. Bart, Cammie, and the children, after the dispute, the divorce moved to Los Angeles, California. So they got divorced, but they sort of all moved together to California to further the professional careers of the children. And then 2 years later, Cammie enters into a relationship with another man. And in 2012, she moved to Arizona. She agreed that the children should stay in California with Bart, where they continue under his management. Then in 2013, she suddenly files a petition for modification of the Superior Court of California, and she suddenly sought full custody of the children. I'm assuming, Megan, this is when music and performing became evil.
I think so. Yes, she decided.
Was that her basis?
Yes, she decided that they shouldn't be in entertainment, and that Hollywood is a dangerous place for children, which I don't necessarily disagree with. But I think the type of entertainment that they were doing is not the kind you'd be worried about. Like they're traveling around with their dad doing magic shows. It's not exactly, pimping out your kid for some Lolita movie.
But even them, here's my issue with this. A modification is usually only brought when there is a significant change of circumstances that would warrant a modification.
Right.
In this case, she knew full and well that the children were singing, that they had moved there. She had moved there with them. And then she absconds, 2 years later. And now she's bringing this modification after the fact. I don't understand how the court even allowed this in.
Oh, they'll allow anything.
She filed it in California, but don't worry, it was filed in 2013. But the case has been pending ever since without resolution and with limited activities. Nothing has happened.
Needs to be dismissed.
8 years. And so then there was a bunch of other moves, and eventually they ended up in Utah. The wife did, the mother. The minor children have since flourished in their entertainment careers, appearing in 2016 on the NBC hit series America's Got Talent, making it to the semifinals, performing nationally, internationally, et cetera, et cetera, et cetera. Now the Judge Amy, before his elevation, this is where I started reading this and went, Megan, this is fucked up.
Oh, I know. It gets worse, but this is welcome to Missouri, Jeff. Welcome to Missouri. Every story I hear is like this. There's conflict of interest everywhere in every case.
Yeah.
Judge knows somebody's brother. The judge is sleeping with somebody's wife. Honest to God, that's the story in Missouri.
So before his elevation to the bench, Judge Amy was the personal attorney of the father's mother on several matters, including her divorce from Bart's father. So Bart is the father of the children. The judge in this case was the lawyer for Bart's mother, including her divorce from Bart's father. And Bart and his mother were estranged. So Bart sided with his father in the proceedings, where his mother was being represented by the judge who is now doing shit to his kids.
Yep.
And it gets worse. Because
it gets so much worse.
We can scroll down to some stuff here. Mrs. Lutenbacher, his mother, and then attorney Amy had a falling out over his alleged negligence in defending her in a traffic ticket. So get out your little 3x5 cards and your string, because we've got a judge who is shitting on a father and doing stuff to his kids, is the judge that represented the father's mother in a divorce proceedings, and then later had a bone to pick with the plaintiff's mother because she accused him of negligence in a case that he handled for her. Are you seeing any problems yet, Dani?
Oh, so many. Oh,
we're
so
just getting
I
started.
mean, the
think
main problem being that he was negligent in defending her against a traffic ticket. I mean, that right there raises immediate concerns.
Well, and also like someone in the chat is saying that's not necessarily a conflict. If that's not a conflict, the judge having a personal relationship with your mother who you're estranged from, I don't know what a conflict is then.
Yeah, it's not technically a legal conflict as I see it, but it certainly is a moral and perhaps ethical.
I see it
Conflict.
as a direct legal conflict. And as a matter of fact, I would have moved to have the judge recuse themselves. I
Just
would
wait.
have had-
tried. He
It's
tried.
coming.
I would have had that case moved. I would have been like freaking judge shopping. I would have been out of there because here's the thing. The reason there's a legal conflict for everybody who's confused about this, the judge representing mom is privy to information
That's brought
from
up.
mom's perspective
Mhm.
that no one else would be privy to, that may influence and sway their opinion and judgment in this case. That's why there is a legal conflict here, in my opinion. And I think that the judges really should lose their license.
Well, let's see how poorly this was handled. So Cammie files a new modification petition in Missouri. So there's still the one that's been pending since 2013 in California, but she wants to do a new one in Missouri. So now there's two separate
And she doesn't
modification
live there.
petitions.
She doesn't. Nobody lives
She lives
there.
in Utah.
Wait,
the
wait,
kids
whoa,
live in.
huh?
Yeah, no, she lives in Utah. The kids live in Louisiana with the dad, and they're performing in Tennessee. And so she files in
I think actually
Missouri.
at this time they might have been still in California, and she
Yeah, that's
filed
right,
in
yeah.
Missouri
Yeah, they
Why
moved
did
to
she file?
because she.
because she's
I'll
a
tell you
bitch.
why. I'll tell you why. There is some question
Judge.
as to what the relationship she has with the judge.
Oh
She
no.
filed. She filed in Missouri, I believe, because she had some connection to
No,
that
no, no.
judge in Missouri. I don't know what the connection is, but I
Ooh,
believe she
no.
knew him.
Maybe, or she knew that she would get what she wanted.
Exactly. I think
So she was
somehow
like,
she got the information that
jurisdiction be damned.
if she filed in Missouri, she would get what she wanted. Right.
Yep.
And
Yeah.
Rose, mod and member of the Clean and Sober Crew for 5 months, says proud member and mod for this awesome channel and creator. Oh, thank you. With great guests. Of course, we have great guests. We enjoy wonderful content and great emojis. Hit the thumbs up and sub and become member today. And Jay Louie says, thanks, Megan and Dani, for bringing these stories to light. We're in St. Louis County Family Court. If anyone wants to help read our story or pray, please consider us at Give Send Go Mo Family. Go check it out. There's
A lot
sounds
of
like there's a
families
lot of this going
suffering.
on, yeah.
A lot of families suffering in Missouri.
And
you
Sweet
guys.
Gator Babe has given us a sticker.
I kind of feel
And-
like living in Missouri is suffering enough, don't you?
Anonymity
Just-
T too.
Just driving through it is suffering enough.
It steals a little bit of my soul every time I even look at the map.
Click join, hit the 3 dots, go to gift settings, then hit allow. You'll be able to be gifted subs now. Yay, get your gifted subs. All right, so she wants this new thing here in a state where nobody lives. So at the time of filing, neither Bart nor the children were living in Missouri. Cammie was living in Missouri. She was living in Missouri, but then she moved to Utah in 2019. Like right after she filed, she moved to Utah. So under the Uniform Child Custody Jurisdiction and Enforcement Act, Judge Amy lacked jurisdiction because
Duh.
neither the child, because
No one
neither the
lived
child
there. No
nor
one
the
was there.
parents-
There was no jurisdiction. You don't even need to pull in the friggin' UCCJEA. All you need is general rules of jurisdiction.
Yeah. And substantial evidence was no longer available in Missouri concerning the child's care, protection, training, and personal relationships. Well, as Dani said would be a good idea, Bart, he files a motion to dismiss for lack of jurisdiction,
Very wise.
or alternatively, an inconvenient forum.
Yes, very wise.
Well, Judge Emmy, he denied. See, this is
He
the thing.
just
When you're
denied
telling
it.
a judge, that when you file a motion to recuse a judge or to deny the judge's jurisdiction, the judge decides whether he should be removed or has
See,
jurisdiction.
that's so wrong. Another judge should decide it, not the
I
judge
agree.
that you're asking
I
to
agree.
step down. His chief justice, the chief judge, should decide on a motion like that. Letting this guy decide his own recusal is stupid. It's just retarded. Stop it.
In part, I agree, but could you imagine all the self-represented litigants who would be bringing these motions willy-nilly just so that they can tie up the courts? That would be my only concern. But here, I agree with you. It really should have been heard by another judge. It should have been heard by a judge who had jurisdiction. So I hope he filed a motion in limine to have this moved, or filed an appeal immediately saying, hey, look, I need this to, or file a motion. I would have filed, honestly, for a modification in the state where they were. I would have just filed for a modification right there.
Oh, it gets so much worse.
Petition to modify, and then tell the courts, look, we have an open case here in California. It's already being decided.
I believe there was a phone call between Judge Amy and the judge in California, wasn't there?
Oh, no. He said there was, but we'll get there.
Okay.
Oh, no.
Oh, yeah.
Okay,
it gets so much worse.
Yeah.
It gets so much worse.
So what happens now? September 19th, the mother, Cammie, files a motion to require the father to return the children and restrict further contact. And she files a notice to shorten the time for the hearings. So it was supposed to be later, but she wanted it to happen sooner. But the father and the GAL, the guardian ad litem, the lawyer acting for the children, they both filed objections to the notice to pull the trial in sooner because one's going to be out of the country and the other's not going to be available either. But the judge said, well, who cares if the father and the lawyer for the children aren't present? He held the hearing alone with the mother's counsel.
Well, what? That's not...
Dani, this is what they do in Missouri. You don't understand.
This is not real.
Every family I know in Missouri, there have been secret hearings where they and their lawyers were not involved, or their own lawyers went to a hearing without the litigant and met with the judge in secret and decided their entire case without their input. This has happened to every litigant I have spoken to in Missouri.
Can I do a little law splaining here? So this is a due process issue. And whenever
there's no due process in Missouri,
in family law, whenever you have any type of hearing, notice is the primary issue. Every time, it doesn't matter what the actual underlying issues are, you need to address notice. So the other party was on notice. They received multiple notices. They said they could be here. At the last hearing, they said they could be here. They're not here. So now we're having a continuance against my objection, right? Like, you make sure that everyone knows who is and then when you actually file your order, because most people don't realize this, the court doesn't draft your order. The court will tell you to draft the order as the attorney. So when you go to draft your order, you have to put everyone who was at that hearing in person. And if it doesn't include both parties, the chances of the court accepting your order are very slim to none. On rare exceptions, very rare occasions, they will do ex parte hearings.
Well, and here, I mean, this is a case where the hearing date was set and they didn't want to extend it. She alone, all by herself, the mother, wanted to make it happen faster. Like, oh, we're going to be out of the country and we're going to be busy. And the judge says, well, that's just too damn bad for you. We're going to have it only with the mom's hearing. And here's his notes. Here's his judicial notes on the docket entry. Counsel for father is not in country. Court is concerned that children have not seen mother in 15 days. This case remains on the trial docket for October 8th. This type of behavior does not bode well for a joint parenting arrangement.
Is he high?
Yes, he has black robitis.
Someone get him some freaking chill pills and meds. Like,
my sister,
delusional.
My sister,
here we
the
go.
Appellate attorney. She goes,
"Oh yeah,
he needs a psych evaluation."
No, he absolutely does. 15 days away from the mother. I have clients who haven't seen their kids for 2 months, and the court will still extend the hearing because it says you have to in the rules of civil procedure.
Yeah. So Bart, the father, his lawyer files a new motion to vacate, again, raising the UCCJEA arguments as to why the judge lacks jurisdiction, and alternately, that is an inconvenient forum. Yes. Well, all of the hearing, everybody shows up to the hearing, and then he mentions in the docket entry that everybody appears, and he just says the court will attempt to set up an evidentiary hearing on jurisdiction, but in all likelihood, it will occur on October 8th. So he's plowing forward. But then the day before the October 8th hearing, there was a hearing in the Los Angeles County modification case. So dad packs up the kids, brings them personally to California for the hearing in Los Angeles on October 7th. They were present in the courthouse, in the LA courthouse, but remained in the hallway. And then as soon as that October 7th hearing ended, Bart and the children raced from Los Angeles to Forsyth, Missouri. They flew from LA to Joplin via Dallas and then drove to Branson, arriving after midnight so they could be at the 8:30 a.m. October 8th hearing.
What a bloody nightmare. And I said rules of civil procedure. What I meant by that was our rules of professionalism, and professional conduct require that. But for those who are unaware,
in Missouri, they don't give a shit.
This is such a bloody nightmare.
They violate their rules of procedure constantly. And if you file a complaint, I have evidence that I have entire binders full of these complaints, and they throw the complaints right in the garbage. Not one of them has been investigated, Dani.
Oh, this is disgusting. Yeah, I mean, the first thing that the court should be looking at when it comes to custody evaluations, when it comes to modifications, is what is in the best interest of the minor children. I can guarantee you, forcing the minor children to travel across the country and drive all through the night to be at a court hearing they shouldn't even be involved in the first place is not in the best interest of the minor children.
Yeah, well, and Chi-Chi here says, so are these children legal adults now? No, they're 13 and 15 years old right now. And so I'm not understanding all this. Is it about just holding the corrupt judge accountable for past acts or money? No, all of this shit we're talking about now is laying the foundation for the really bad stuff that happens in a little bit here, in a few pages. This is background to the bad shit that they're going after the judge for now. So this is just a warm up. This is the aperitif. This is the little foam on the uni resting on the saltine cracker they give you at the beginning with your complimentary champagne.
I need to go get more coffee for this. I'll be right back.
Okay.
I need some complimentary champagne.
So they go to the 8:30 a.m. hearing in Missouri. The children, they hadn't seen their mother for approximately a month, and when they initially saw her in the courthouse lobby, they refused to speak to her. The children understood that their mother had put obstacles in the way of their entertainment careers, and that's what you were saying, Dani. The kids, by and large, loved doing this. Yep. They loved having their careers.
Yep.
For example, they canceled a South American tour and refused to let their children leave her custody for auditions. They refused to visit with her and said they were done with her unless she would drop this modification case. So, I mean, if children desperately want to avoid their parents, one of their parents, there's some serious issues that should be looked into by the court.
Yeah, and I mean, there should have been a full custody evaluation, but I don't think that the courts knew that this woman was so cray-cray and that this case was going to get so crazy. What should have been done is, in a state where they had jurisdiction, they should have done a custody evaluation. For those who don't know, a custody evaluation is basically you get a custody evaluator. This is someone who is generally a psychologist or has some kind of experience in family education, growth, children development, and they will meet one-on-one with the PGAL or the GAL, guardian ad litem, with the children, with all the parties involved. They will look over all of their records, history, financial means, everything, and they will basically write up a report and give it to the commissioner or to the judge as a recommendation on who gets custody, how much time, and what those visits will look like. In this situation, it's a two-way sword, or the sword cuts both ways. On the one hand, you could say, well, yeah, they're refusing to visit with her because she's a biatch and she's ruining their lives and career. But on the other side, you could say that dad is engaged in alienation type behavior and gatekeeping and is manipulating the children to act against the interest of building up the relationship between mom and minor children. So in these types of situations, a custody evaluation is what you would be seeking. At this point, with the minor children being 15 and 13, I'm pretty sure the 15-year-old can seek to separate themselves from their parents. And that's what I would be seeking.
Yeah. Well, we've got about 30 pages to burn through here in the next 10 minutes. So
I will say nothing for the next 10 minutes.
well, we'll get your comments here as we go along, but this is we're ramping up to the present day here, the present lawsuit day. So they refused to, they were done with her unless she drops the case. And then Judge Amy, and they had this big deal where the parents, they went into the court. Well, we'll get to that. I'm getting ahead of my own self. So the children there, the Bart's mother and father, I mean, the kid's mother and father, they had to work all this stuff out. And the GAL is telling them, you go hug your mother. And they're like, we're not comfortable with that. So they didn't have to do that. So Judge Amy stated words to the effect, told the parents, go work this out or the kids will be out of the entertainment industry. The judge said this in the middle of a custody hearing. He has no fucking say in this. So he just tells them to go work it out or the kids are going to be out. And then his words led Bart's attorney to believe that if the case went to trial that day, then Bart would lose custody. So if you don't get this worked out, you are going to lose if this goes to court. Judge Amy asked Bart if he would be willing to move to Utah to be able to see his children, which led Bart's counsel to have concern that Judge Amy would give Cammie custody of the children. So then Bart's counsel, they have this big negotiation, the settlement negotiation. Bart's counsel informs him the children would go home that day with Cammie and dine with the mother and the cousins and everything and spend the night at the mother's at her hotel accommodations. And Bart said, that's cool, fine. But he said he suspected that the children would resist going with their mother. And this arrangement that the children would go with their mother that day wasn't memorialized in this settlement agreement they reached. And the father says he reached this settlement under duress because he was afraid he would lose his children. So the attorneys told the judge the terms of the settlement, and the settlement gave legal and physical custody to the mother. He just basically gave up physical and legal custody, but he was allowed to see them from the 1st to the 10th of each month, and from the 1st to the 15th during summer vacations and during TV pilot season, so roughly January through April. So he gave up a lot because he was allegedly afraid that the judge would just rip his kids away from him and give him no visitation if he didn't agree to settle on her terms, basically. So he tells the child, this is the court-ordered child counselor, Dr. Baker, that I don't think the children are going to go for this settlement agreement. Well, what do you know? The kids did not agree with the settlement and refused to go with their mother. The children told her that they did not want to go with her at the end of the day and did not want her to have any part-time custody over them. The children said they don't want to live even part-time with their mother. And so now this is where we begin the basis for the legal action against the judge. This is where the really bad shit starts to happen. So this is present time, 21. This is October 2021. So Bart, the father, doesn't know that anything wrong is gone. His kids' cell phones are in his mother's car. So he goes out to his mother's car to get the phones for the children. Court officers start shouting at him to leave or be arrested. What? He was startled and confused. After it became apparent the officers were directing their statements to him, he explained that he had to give the children the cell phones. The officers refused to provide a badge or ID number and let Bart take photos or recordings of them.
What?
So Bart they just told him to get the fuck out. And so not wanting to go to jail, he left without delivering the cell phones back to his children. So now while all this is going on in the parking lot, let's go back into the courthouse. And this is where the shit goes down. Back in the courthouse, the counselor, Dr. Baker, and the judge were having a conversation. The judge was court was over. The judge was no longer in his robes. He was in the public lobby area of the courthouse. And then he took this meeting into a private room, and the kids were explaining that they did not want to go to their mother and why it was wrong that they have to go to their mothers. Well, he said, you have to stay with your mother, and the kids disagreed. Then he proceeded to lecture the children on the evils of Hollywood and the need to grow up normal. That is, without working as talent in the entertainment industry. He told the children they needed to listen to and live with their mother in Utah.
Oh, hell.
And of course, normal for them is what they've been doing. Normal is the entertainment industry. Normal is totally subjective.
Dani, comments?
First, whoever drafted this did a great job, because I feel like I'm reading a novel and I'm seeing all the players. I'm seeing everything as it's playing out. This is very well written. Second, yeah, this is effed up beyond effed up.
Well-
One, if any of you guys have ever seen a First Amendment audit, go watch them on YouTube. They're so fun. So basically, these citizens go and piss off the government by filming them. You have the right to film police officers. You have the right to bring a camera with you. What is insane, though, is that in the very rare circumstances, I've said this once, I'll say it a million times. I agree with Nick Rekieta. There should be a camera in every courtroom, except where minor children are involved, to protect the identity and the privacy of the minor children.
I still think we could get around that, Dani. We could get around that easily by by not calling the children by their first names and putting them behind a screen. Period.
Right, and we already do this, right? Even in our pleadings, as you can see here, we use initials and yep. And so here, though, it's insane because Judge Amy, am I pronouncing that right?
Yes, you are.
Is basically circumventing that rule and having public open dialogue regarding this case in like plain clothes in the lobby of the courthouse with the minor children. He should
telling
not
them
be
about their
discussing
career
this with
choices.
minor children, period. Outside of like earshot and direction from both parties and the GAL. I mean, this guy is disgusting. It would not surprise me that this judge is also their bishop. I'm just going to say that. Leave that there.
Well, here we go. This is it's getting worse because the KR, he asked the judge how his professional entertainment work was different in kind than being in high school band or a cheerleader. At this point, Judge Amy became visibly agitated, stated words to the officer to the effect of, "I will show you what I can do. I can put you in jail," and told the children to follow him.
Oh my God. Why is he fighting with children?
"I don't know how you have the right to lock us up. We've done nothing wrong." They get back and forth. They go down various hallways to different rooms where they where there are doors to jail cells.
What the hell?
I just want you to put yourself, though, in the position of a 12-year-old. I have a 13-year-old. She would be so terrified being marched down to a jail cell by any adult. This is, I mean, we snicker and laugh because it's outrageous, but these children were literally terrorized by a judge. And that is so sick. And it's such a bad thing that has happened in this country where judges feel that they can do anything they want to anyone, even little children. Like, somebody does need to cane this guy. I want to see him bent over in the public square getting his ass caned.
Are you saying like make tar and feathering great again? Because I'm in favor of that as well.
That's exactly what I'm saying. I like her. I like her, Jeff.
I like you too, Megan.
Yeah. So here we are. Let's keep. We've got like 2.5 minutes to get through 17 pages. It's not gonna work.
I'm sorry.
We're going to go a little bit over time. So anyway, they go back and forth, and then the Judge Amy's face was red and he was breathing heavily. He angrily ordered the children to take off their shoes, socks, and their jackets. KR was wearing a bracelet which KR had obtained at a church camp and had made a religious commitment not to remove. Judge Amy, after learning of this, ordered KR to remove the bracelet anyway. Religious freedoms, anyone? Judge Amy and the uniformed officers led the children into jail cells, ordered the uniformed officers to lock KR in one cell and BR in another. The cells were cold and smelly. The children's bare feet were cold. BR stood on a raised mattress because her feet were cold and they made her get down off of it. On inference, at least one of the two uniformed officers was thus watching the children by video camera. There were open toilets in each cell, but the children were afraid to use them because of concern they were being watched.
A very, very well-founded concern.
Yep. An hour more or less later, Judge Amy and the uniformed officers returned and removed the children from their respective cells. They gave them the "Are you ready to listen to me? Are you ready to comply?" lecture.
Oh my God.
The officers were present. Judge Amy said words to the effect of, "Will you go with your mother or do you want to go back in there?" BR replied to Judge Amy with words to the effect of, "Respectfully, how can you just lock up kids? This isn't legal. We've done nothing wrong." KR added words to the similar effect. Judge Amy stated words to the effect of, "How would you like me to take you away from your parents and send you to live in the Missouri foster care system?"
Okay. First of all, How bad is it that the judge is threatening foster care?
Mm-hmm. So
Like,
the children,
not just
yeah.
that the judge is threatening it, but that he acknowledges how bad their foster care system is, and he is utilizing that as a threat against the minor children.
And it is bad, Danny. They lost 1,000 children in Missouri DSS. 1,000 children went missing without being reported. 1,000 foster care children missing in Missouri.
I can guarantee you the same thing is happening in every single jurisdiction across the
Yeah.
United States.
And so the children, fearing further jail time under foster care, stated they would comply with Judge Amy's directive to live with their mother in Utah. I now got to make the midstream grift here. God damn it, people, stop fucking talking about Farron and bringing shit into my channel. We're not stirring up shit here. This isn't the fucking Farron stream. If you don't like it, get the fuck out and come back. Mind your business. Don't come into my house and
Why
shit
would
on
you
me,
invite them
my
back?
guests, or anyone else.
Why
I
would you
don't
even
know,
invite them
because-
back? Get out
because
and
they're
don't
fucking
come
idiots.
back. Don't.
If you
Don't.
have a problem with Farron, go to fucking Farron's channel and talk to her about there. Don't bring the shit here. We're talking about serious issues here. We're
Or
talking
go
about
to jail and
the
comply.
torture and terrorism of children. Knock the shit off. It's not being tolerated today. So can it? Seriously, respect me as I respect you. Don't shit on my guests and don't disrupt things. Just grow the fuck up, act how you are, and bring things. Otherwise, it's because don't be an asshole. That's just it. All right. Judge Amy is being Judge Amy here. So they go to live with they say, okay, we'll go to live with your mother in our mother because we don't be locked out. Well, he says, okay, fine. You are going to live with your mother in Utah.
Oh my
BR
God.
then shook her head. Judge Amy yelled at BR and said, what did you say? Did you say something? You sure you didn't say something? She said, I didn't say anything. At this point, under duress, in order to avoid further jailing, the children stated to Judge Amy that they would go live with their mother in Utah. So at some point, it's 5 o'clock at night and it's too late. So Cammie, the mother, texts the father and says that Judge Amy had locked up their children in the courthouse jails. Well, there's...
How
with
did
approximately-
mom know and not do anything for how
'Cause she's a
long
mother.
those kids were in
She
jail?
probably blamed him for it.
Oh, I'm so mad.
So with approximately 36 hours, within approximately 36 hours, the children left with their mother to go to Utah. At no point had either child entered the courtroom or attended any part of any judicial proceedings. At no point was either child accused of, found to be delinquent or in contempt of court. At no point before the jailing did Judge Amy notify the guardian ad litem or Bart that he was going to jail the children, or provide any party or attorney involved an opportunity to be heard. At no point did Judge Amy ever make a record of the filings or enter the orders jailing the children. At no point did the children have any access to any process of law related to their jailing. So in the days after their jailing, the children returned to Bart's custody and care. On October 30th, Bart's attorney filed a motion for change of judge for cause. Okay, that sounds great. But again, remember, it's the judge that decides whether or not he should be released. On October 31st, Judge Amy held a hearing with counsel. Counsel for Bart and Cammie each asked Judge not to approve the settlement. So this whole settlement that they agreed on, this whole settlement agreement they came up with, and that resulted in the children going to jail. Now, both of them are saying, we don't want to do this anymore. Don't approve that. Both the mother and the father said, set this agreement we made aside. We don't want it anymore. And because there was problems with it and the children weren't complying. However, even though both parents didn't want this to be signed and made official, Judge Amy approved the settlement and signed the judgment of modification.
That's
There's
not
no
how this
excuse for
works.
that.
That's not how
No,
any of this works.
I know, Danny.
There's no excuse for that. None. The
I'm
judge
losing
is
my
completely in the
goddamn
wrong.
mind back here. I'm gonna shut the hell up before my internet goes out again.
No, seriously, I mean, this is it. The children, they made this big agreement. It wasn't signed. They were going to finalize, and they said, never mind. Both of them said, we don't want to agree to this thing that we agreed to anymore. And the judge
It's
said,
not a
well, screw
settlement
it.
then. It's not a
Yeah.
settlement. It's a
Yeah.
judgment. The judge is ordering this without jurisdiction. That's what this is.
And without consent of either party. Which
Yes,
doesn't
that's
make
why it's not a settlement. This
any
is completely
sense.
made up.
just that's
He's
not how
literally
divorce
pulling this
court
out of his
works.
ass and then forcing the children to give him answers he wants to hear.
So Siladon says, what would happen to the judge other than losing the job in case it went through the court? They're suing him for a fuck ton of money for lots of violations. And that's what we're going to get to here at the bottom of this document. In the meantime, we've got a couple super chats to burn through here. Roscoe P. Coltrane says, here, since I forgot to use your code when I bought tea from the tea man, don't make that mistake again. Kyle Cowden says, like restarting ECT treatment just for the judge. Skies a Neighborhood says, why is it so bad in Missouri? Guerrilla judging is wild.
I love the guerrilla judging. Guerrilla judging is perfect to explain this.
And third-party intervener on behalf of the client, I'm curious whether judicial immunity confers invulnerability to lead and brass. Just musing. Yee. Chaos coordinator, I don't have enough whiskey for this case at home. I'm trying to recover from sickness, but now I may have a heart attack from anger. WTF world. Right. And Anakami1 says, I think there's a way this judge should be handled, but YouTube and polite society say it's wrong. Use your imagination.
I disavow.
And Julie O, I dated a guy named Farron once, caught him out with another girl, so I ordered a cranberry and vodka, walked up and threw it at him on his shirt. F that guy. All right.
F that guy.
Thank you so much. F that guy. All right, so we just get back to the case here. We're going to run overtime. We got 1,115 of you here. Thank you for dealing with this. We're going to run a little bit overlap with the Murdaugh trial, if that's what you're waiting for, but I hope you'll stick with us. We're probably going to run like 15 minutes overtime is all.
You're going to want to stay to hear the audio of the appellate arguments. You're not going to believe what you're going to hear.
This is crazy. So he approves it, and then he says the motion for change of judge denied. He just said, nope, sorry, I'm not going to change myself. Mother's post-trial motions denied. Judgment signed. Court has heard that the parties are already having trouble. No party now resides in Missouri. Court encourages mother to register the judgment in Utah and request relief from the state's court under the emergency provisions of the UCCJEA. So he stirs up more shit. It goes on. And although Judge Amy made a determination that he had jurisdiction, he did not follow the statute for his communication with California courts. Because the Missouri court, when they talk about jurisdiction, when you challenge jurisdiction, they're supposed to call the California court, which already has jurisdiction, has been hearing it since 2013. They're supposed to call and make this deal between them, say, okay, do you want to give up jurisdictions? Can I have jurisdiction? And they hash it out. Well, apparently he never did.
Which is why I recommended filing in a different jurisdiction, filing in California for said modification, just to remove jurisdiction from Missouri, just to get a court in California to say, hey, this is ours.
Yeah, there is no record of that conversation between the courts ever taking call. The California court's electronic document record shows neither no finding or a record declining jurisdiction, nor a record of the call. Well, it's Bart's turn for custody. Bart came to Utah and picked up the children. The children refused to return to their mother's custody thereafter. Bart filed a police complaint with the local law enforcement as to Judge Amy's action in locking up the children. He also filed a judicial complaint. So Bart's complaint went nowhere after Judge Amy told the police officer that he could not comment on his actions as a judge.
Oh my God.
The police dropped the ball in a big way there. So now here is the second jailing of the children.
Why are we jailing the children?
Because
in spring 2020. Yeah. Children traveled from Los Angeles to live in Union Parish, Louisiana. So now nobody lives. Mother lives in Utah. Children lived in LA. Now the children live in Louisiana and they're working in Tennessee. Nobody ever sets foot in Missouri anymore. So they moved to this farm for quarantine purposes. The kids did perform 3 weeks of shows at the Theater of the Stars in Pigeon Forge, Tennessee.
Really lovely little theater there.
Is it? Oh, okay. Cammie filed a motion for civil contempt in the Missouri courtroom, alleging that Bart was withholding custody of the children, and Amy signed a show cause order, which is essentially ordering the father to say why he is violating court orders and not letting the mother see the children. Well, they were going to this Pigeon Forge theater, this Theater of the Stars. They were co-headlining with the winner of the NBC television series The Voice. They travel there, and while he's in Tennessee, the Missouri court serves him in Tennessee though he lives in Louisiana, and the motion was filed by his mother in Utah. This whole thing is just fucked up. But anyway, they get served process. And so Cammie started calling the procedures of the pigeon. The mother started calling the producer of the show, telling them Bart didn't have the right to book the children. This causes confusion and issues with the children's contractual obligations.
Oh my gosh.
And so the judge issues an order for Bart and the children to appear in his courtroom on August 13th.
I hope that they sue the judge for tortious business interference too.
I don't think that's part of it, but I think there's plenty here to get him on.
Yeah.
So now we're getting down to business. Bart's new counsel files a motion to disqualify the judge for cause, to dismiss the civil contempt motion, and a motion to continue the hearing so that they can just do discovery here.
Sure.
Well, Judge Amy denies both motions. And then the next day, the judge issues 2 orders. Remember, this is a Missouri judge. The children are in Tennessee. He issues 2 orders to pick up the children and a writ of bodily attachment, which I think is an arrest warrant.
It's a warrant. It's a warrant.
It's a warrant for arrest for a person. Any person. So it's not really an arrest, but it's similar to an arrest because
but just wait. Just wait.
Okay, I'll shut the hell up.
Megan, can you put the link to the video, the pickup video in the private chat?
Yes.
All right. So the judge issues an order for the children in a different state to be picked up and the father to be arrested. And on September 10th, so this is about a month later, Bart's attorney files a petition for the writs of prohibition against Judge Amy, asking them to prohibit the judge from proceeding further with the contempt motion, prohibiting the judge from enforcing the arrest order against Bart, and prohibiting him from enforcing the pickup order for the children, and to compel him to disqualify himself from the case.
I want the Missouri court for a writ of prohibition. That's fun.
Well, not fun enough because the Missouri Court of Appeals denied it within 24 hours.
Fuck.
So 5 days later, he files a similar petition with the Supreme Court. The Supreme Court, they ordered it to be briefed. Now, this is the interesting thing. We're September 15th. The court says, okay, the Supreme Court says, we'll look at it. Prepare your briefs. Well, while that's going on, in November, the Union Parish deputies show up at the family farm on November 18th, 2020, and said they were there to take the children. Okay, I guess this was in Louisiana, right?
Louisiana.
Yeah, they show up in Louisiana. The children are in Tennessee, and the dad says, okay, I'll go get the children and bring them back. So yeah, they said that they showed up at the family farm and said they were there to take the children to their mother at the sheriff's department. The deputy said they were enforcing Judge Amy in a different state's pickup order against the children.
Imagine the sheriff who agreed to do this.
Yeah.
I mean, why, as the sheriff of a different state, do you not look at an order from an out-of-state judge and go, fuck this guy? I'm not doing shit for him.
Because they don't really have they don't actually have a lot of leeway in these types of orders. And the sheriff doesn't know all of the ins and outs. They're not an attorney. Moreover, they're not an attorney.
Does a Missouri judge have jurisdiction in a Louisiana county?
No, absolutely not.
So
what
as
should have
the
been
sheriff,
done
he could have said no.
It should have been domesticated. Okay. But this sheriff has no clue. They're not an attorney. They're not a judge, and they're terrified of being screamed at by the judge.
These are the 2 children here. This is the actual video taken at the time that they were arrested by the police. Now listen and tell me if you guys think that this is the children being placed under arrest. Tell me, does this seem like an arrest to you? Dani, I'll be interested to hear your comments on whether you think the children were placed under arrest during the course of this video.
She's gonna do to us. Being honest, I am more scared of her than having some thing on my record.
You don't know that because you never have dealt with it.
I'm pretty sure that I understand
what she does. You don't understand what she's done.
We do not have a choice. This is nothing to argue about. This is nothing to discriminate about. You have to go with us. Let's go.
Sorry.
I'm afraid. what she's gonna do to us. when we
Y'all have
go
the right
to
to remain
jail.
silent. Anything you say can and will be used against you for a law. Your right to an attorney. You can't afford
That's an arrest.
That's an arrest.
You understand your rights. I'm asking you to stand up and let's go, or you will be arrested.
He just read them their rights.
He just arrested them. He's
Oh, wait.
detaining them already.
Watch this.
You're under
You're
arrest.
under-
He just
he
said.
says
Are
you're
you
under arrest. He
freaking
handcuffs
kidding
them.
me? Oh, that son of a bitch. I was going to say.
Don't you want to
oh,
kill him? I know.
100 times.
Look at manhandling these children.
Listen, I was giving him the benefit of the doubt. I was on the sheriff's side till now. F him. F these people. May they rot in hell forever. I cannot believe that they would just walk
They
right over
handcuffed the
Constitution
girl
like
too.
that.
They handcuffed the little girl too.
Wait. They put them in separate cars. This is psychological trauma and torture like you've never heard to what they do to them next.
And that's-
Danny, you're going to get so mad. So I don't know.
I'll keep myself on mute.
So, all right. Now,
All the curse
Danny, did that seem to you as if the sheriff had placed them under arrest at some point during that?
Oh yeah, no. The minute they started reading their rights, they were
That's
under arrest. And they arguably could have been under arrest when he was barricading them in a certain area and they were surrounded by police officers and there was no reasonable way that they thought they could escape or leave without otherwise being arrested. And then he told them, you don't have a choice in this. All of those things would lead a reasonable person to believe that they were under arrest.
So what about when he said you're under arrest? Would
That part
indicate
too. That was
and what
part
about-
too.
What about when he handcuffed them behind their backs? Would
part
that also
too.
be all right? Well, the children
Absolutely
told the
an arrest.
deputies that they would not leave Bart and would not go to Cammie. The deputies argued with the children, telling them they had to leave the home with them. Approximately 30 minutes, the deputy read the children their Miranda rights and then handcuffed KR behind his back. KR did not arrest. BR was also handcuffed and was also compliant. The handcuffs caused physical injuries to the children's wrists, particularly pain. The children received no medical treatment. After the arrest and the reading of the Miranda rights, including the right to counsel, BR, the smart kid, asked for a lawyer.
I love BR, man.
And they
She's my
have
gal.
lawyers. And they
The
have
deputies,
a lawyer.
yeah, they have. He's a 15-year-old. He actually does have a lawyer.
Yeah.
The deputies responded that she was a child and her parents would have to hire a lawyer, and that children had not been arrested and so had no right to an attorney.
That's not how any of this works. This is now kidnapping. This is
Yep.
not an arrest. This is
Mhm.
child kidnapping.
Yep.
Woo!
They literally arrested them and said they were under arrest and read their Miranda
then
rights.
denied them a
Have your
lawyer.
place under arrest, and they exercised their right to a lawyer like a smart little girl should. And they said, "So no, you're a child. The rights don't
You don't have a right to a
apply
lawyer."
to you, and
No.
you weren't arrested."
Jeff, I got to tell you, people really believe, authorities of the state really believe children don't have a right to a lawyer, by the way. Because I'll give you a perfect example of this quickly. I sent a letter to our school superintendent telling them that my children have a lawyer. And should any agent of the state come to interrogate them from CPS or the police or anything else, that they are to immediately alert their lawyer and that my children will invoke their Fifth Amendment right until their lawyer gets to the school. Their attorneys sent me back, my attorney back a letter that said, we will not comply because they said that we have no duty to alert a lawyer in that situation. And I told my lawyer asked me, what do you want me to do? And I said, nothing. Put that in the file. And if they ever do it, I've got them. Because that's bullshit. These people really believe children don't have a right to a lawyer or they don't have any constitutional rights. And that is not true, right?
Yeah. Oh no, not yeah. Yes. Yes, you are right. The Supreme Court has been very clear in this. And as a matter of fact, it was the Supreme Court that said that minors and children do not take off their constitutional rights at the schoolyard door, right? So it's not like, oh, well, now that I'm pretending to be now that I have no other rights in my life, practically, I also lose all of my constitutional rights. That's not how this works.
Nope.
This is an absolute violation of these children's constitutional rights, starting from
And don't they
them
have a
being
special
placed
duty?
themselves being all of this.
Don't they have an actual special duty to protect the rights of children because they're minors? So there's actually a special right for the police to provide an attorney or an adult to be
Yeah,
there
that's-
with the children, correct?
That's what the
process
GAL's
should
for.
be increased, not decreased.
Exactly.
Well, Dani, are you ready to lose your shit completely?
No.
It gets worse.
Well, get ready to lose your shit completely, because here's where we hear people. What do you got? 1,200 people here watching now. Almost 1,300 people watching this. Watch what the hell happens next with these children, these 13 and 15-year-old children that are handcuffed under arrest in the back of 2 separate police cars because they don't want to go with their mother. For whatever the reason is, they don't want to go with their mother. So the deputies place the children separately in the caged back seat of respective police SUVs. The children are terrified because they could not communicate with each other. Deputies then drove the children to the Union Parish Sheriff's Department, where Cammie was waiting in her van. By then it was late in the evening, long after dark, and the children were tired and had not eaten since breakfast. Well, Cammie exited her van, and the children argued with her in a standoff. These children are handcuffed in a police car, and they still don't want to go with their mother. That's how badly they don't want to go with her. And it's what the kid said. I would rather have a criminal record than go with my mother when he was being arrested. So KR kept stating to Cammie that he would not go with her. Cammie went around to unhook BR's seatbelt from the back caged area of the police car, and they argued. BR stayed in the car. The deputies told the children to go with their mother. The deputies, the children, and Cammie all went inside the police station. Cammie wrestled the children's phones away, grabbed BR, and tried to drag her out of the room. Now, this is 4 o'clock in the morning, and the children haven't rested or eaten since the morning before.
This is fucking child abuse.
The deputies drove the children to the
Torture.
Green Oaks Juvenile Detention Center, an hour's drive away.
Why?
So he takes them to juvie. They arrive at 5 o'clock in the morning. On arrival at Green Oaks, each child was strip searched and put in a cell.
Oh my.
It's torture, is what this is.
These children were strip searched.
They
and
committed
put in a
no
cell.
crime. No crime. They were not accused of any crime. There was no actual paperwork of any contempt. There was no reason, no
Mhm.
authority to arrest these children. And not only did they arrest them, but they then tortured them through sleep deprivation, withholding of food, keeping them up all night long, waking them at weird hours, interrogating them without the presence of their attorney or their parent, strip searching them. These people who did this, including the police officers, should all go to jail.
Mhm.
Forget a civil suit. They should go to prison.
I mean, we can't even start talking about whether or not they were in contempt because they weren't part of any proceedings to be in contempt of.
They're
That's
all
right.
operating under color of law. They all need to freaking go to jail. I absolutely agree with you, Megan. This is torture. This is if we did this to an adult, okay, to an adult litigant, we would say this was torturous, that this was a deprivation of their constitutional rights, that they should have
Mhm.
not just some kind of reprieve, but that there should be a public action taken against those who are involved in this type of criminal collusion. This is beyond the pale. This is what, when you hear judges and you hear Supreme Court cases that talk about cruel and unusual punishments, and they're talking about, things that shock the conscience, this is shocking my fucking conscience.
This is
I
it.
am so pissed off. I am
Dani,
going to
we're-
again silence myself.
Dani, we're not done yet.
How the fuck are we not done yet?
It's
So much for the
bad.
silencing part. We're not done yet. So people saying, where the fuck is this is Missouri. This is Missouri, United
doorway to
States of
hell.
America. So now we have a 12 and 14 or 13 and 15-year-old girl and boy being strip searched and put in a cell after being basically deprived of sleep and food for 24 hours. The children went to sleep still without food, but after approximately an hour, so we're looking at 5, 6 o'clock in the morning, the children were then reawakened and subjected to a mental evaluation. Each child was held in solitary confinement cell for 2 days.
Okay, you know what? I'm sorry. Anybody who calls me a conspiracy theorist for asking questions about the acts of our government, just read this fucking case and tell me that you trust any single one of these motherfuckers with your own life, with the life of your children, with your safety, with anything at this fucking point. This is some serious back-ass word bullshit that, frankly, you would expect to see this in medieval England, not in modern day America. This is some real bullshit. This is, you know what this reminds me of actually a lot is MK Ultra torture type techniques. Keeping them up, depriving them of food, putting the threat and duress of
humiliation
under their
strip searching them, sexual abuse.
Sexual abuse. It is sexual abuse. When you are acting outside of the color of law and you're strip searching someone, that is sexual abuse. That is sexual assault. So these kids have now been subjected to sexual assault, deprivation, isolation, sleep deprivation, food deprivation. Now they're getting psychological evaluations, which I can tell you is brainwashing at that point. This is some actual torture.
Well, John Quinn says there's two sides to every story. Let's not get too emotional without hearing the other side.
Wait till you hear the other side. Wait till you hear it.
The other side is they didn't want to go with their mother. That's the entire other side. The judge's argument is he's a special character. So anyway, they were in solitary confinement for 2 days with no visitors allowed, even though the father tried to visit. There were cockroaches in the children's cells. Now, if you remember,
he tried to get a lawyer to get in there. They wouldn't let a lawyer there either.
Now, if you'll remember, the father's lawyer had filed an emergency appeal with the Supreme Court to have the judge recused, to have all of his orders to pick up the children and all of his orders to arrest the father and all of this stuff just done away with. He'd filed this with the Supreme Court. The Supreme Court ordered them to submit briefs on this. Well, this is where these two cases overlap with each other. They've been in this juvenile detention facility in solitary confinement for 1 day, and the day that during the children's first full day of confinement, the Missouri Supreme Court, they handed down their decision, and their decision was a peremptory writ of prohibition in the interests of justice against Judge Amy. So the Supreme Court is telling the judge that everything he's done in this case is now on hold and will not be enforced.
So basically, they're treating this writ of prohibition like a TRO. An emergency TRO.
And they're taking it very seriously. The Supreme Court is.
Thank God.
Because they ordered the judge to vacate they didn't say, think about it again. They ordered him to vacate the orders entered after the filing date, which was before the pickup order. So the Supreme Court said, you must vacate the order to pick up the children, the order to arrest the children. You must, and they further appointed a senior judge, the Honorable Richard Callahan, to preside over the motion to disqualify Judge Amy for cause. So they're not going to let the Supreme Court's not letting Judge Amy decide whether he wants to be dismissed or not. Someone else is going to make that decision. And the court ordered all other pending matters may be addressed once the motion to disqualify the respondent has been resolved. So the Supreme Court is saying, everybody back to square one. It's over. Nobody's doing anything until we decide whether the judge should recuse himself or not. And mods, here's a link for you guys to propagate here. This is Megan's Missouri court investigation files.
That's where you'll find all 27 parts. This case isn't even the worst one I've covered in Missouri, you guys.
Oh my God.
It's not even the worst one. In fact, one of these days, Jeff, we'll have to go over the Michaela Haynes case, because that one will really make you angry. And maybe it'll get people to get off their asses and do something and start, calling the people who need to make the changes, which is the legislators in Missouri who could actually impeach these judges.
And I've got to make another mea culpa here. I said we'd be about 15 minutes overtime. I lied. We're going to be about 45 minutes overtime because that's how I roll. 1,332 of you here right now. The Murdoch trial is going to be starting in about 3 minutes. We're going to go about 30, 45 minutes over. This is so super important. If this is anything you have even the remotest interest in, you're not going to miss anything in the first 45 minutes of that ridiculous trial. This is an important issue that needs to be. So I did invite you and ask you to stick around and watch how this thing ends, because it's crazy. It's crazy how it ends today. There's still one more phase to go. So They've basically, the Supreme Court said this judge is doing nothing. Any orders he's issued are now no longer active. So Judge Callahan ordered a hearing on the motion to disqualify on February 5th, 2021. And they vacated the hearing setting so basically they set the hearing for February 5th, and then for some reason they canceled it. And since then, there's been no further activity on this case.
So are the kids released?
Yeah, they released them to the.
So we're going back in
Okay.
time here.
Okay, sorry.
We're going back in. This was like a jump forward here. Now we're going back to the actual day. So the children were also charged criminally with being ungovernable.
Oh my God, I
Uh,
want to be charged with that so much.
I'm totally ungovernable. That is such a fun thing to put on
That
your
is
resume.
a title.
Man,
I'm guilty
I
of
put
being
that on my
ungovernable.
resume. I was once charged with being criminally ungovernable.
ungovernable. I didn't even know that was a crime. Can you?
It's not.
I didn't
It's
either.
not. This is fucking made up.
I love it.
But I love it for me.
Yeah.
Mhm.
So nevertheless, the charges were promptly dropped. Yeah, because they probably didn't even exist. So after 2 days, the judge had a hearing before the Louisiana judge. The Louisiana judge immediately ordered the children released into Bart's custody. The local judge further ordered the children to remain in Union Parish until the entire process related to the custody issues is complete. And they basically gave the father full custody of the children.
No
So Bart
shit.
has since modified a petition to modify custody, has since filed a petition to modify custody in Union Parish, Louisiana. Union Parish Court entered an order on April 29th, 2021, formally determining it had jurisdiction. So they're saying, we don't give a fuck what California thinks, what Missouri thinks.
Yep.
We're taking jurisdiction over this.
And this is exactly what I would advise my client to do.
And as soon as that happened, the mother dismisses the Missouri case, and Judge Amy entered an order of dismissal on May 4th, 2021.
Oh, that fucker.
So the family law case is pending in Union Parish, Louisiana. Bart maintains custody, and Cammie does not have visitation.
Good.
So now this lawsuit, this was the background to the lawsuit. Now the father has filed this lawsuit against the Judge Amy. This is what he's asking for. On information and belief, the Taney County holding cells in which plaintiffs' minor children were held are intended only to hold adults arrested upon probable cause of a criminal offense. This parish of Louisiana, where the juvie center was, is designed for delinquent children who are detained for being unable to adequately handle their problems and live within the laws of society. It's common for teenagers to not want to visit or live with a parent. There is no legitimate or normal judicial function to the act of seizing minor children and holding them in adult jail cells to teach them a lesson to go along with proposed civil child custody arrangements under any circumstances.
Yeah, we call that kidnapping.
Yeah.
Yep.
Judge Amy has not yet even entered a judgment as to custody. The children were not before the court as party litigants and thus could not be in civil contempt. Bart and his counsel were not notified and did not have an opportunity to be heard as to the jailing of the children. The guardian ad litem, the child's lawyer, was not notified of and did not have the opportunity to be heard. They were also not able to be heard regarding the show cause order or the pickup order. Judge Amy's pickup order resulted in the Green Oaks jailing and was made in complete absence of jurisdiction. Yeah, a judge in one state is really, really, really off base if he orders the police in another state to pick up children from a third state and put them in jail. Yeah. So there's no probable cause for Judge Amy to seize the children for a crime, for delinquency, for contempt of court, or pursuant to any lawful process. Now, this is where we talk about ordinarily, if the judge makes a bad decision, you cannot sue the judge. You can't sue the judge personally because he's just doing his job as a judge, no matter how much you don't like it. But here is where it happens.
I think we should relook at that, though, Jeff. I really do. I don't think I don't think just because the guy's wearing the robe, if he's holding people in contempt illegally, which I've seen these judges do, and throwing parents in jail just because he's had a bad day, I think you should be able to hold them accountable. I hate immunity.
Bad day.
I hate it.
So this is where you can do it. Judicial immunity applies when two requirements are met: a jurisdiction over the dispute and a judicial act. As to the first requirement, a judge lacks immunity He cannot claim immunity. He's not immune to a personal lawsuit when he has acted in the clear absence of all jurisdiction and not merely in excess of jurisdiction. So if he
Ding.
has jurisdiction and he goes a little farther, that's okay for him. But if he doesn't have any jurisdiction to begin with, he's fucked.
So ding, ding, ding. We've met that first element.
We've got that one. And Judge Amy's acts in seizing the minor children were not done pursuant to any pleading or motion before him. Were not done pursuant to any contempt order. Were not pursuant to any process of law. Were not done on the record pursuant to any finding of fact, conclusion of law, order, or judgment of the court, or any record whatsoever. They do not appear in any court filings or records. He didn't even go back later and say, I'm issuing an order. I issued an order to have these children taken. He didn't even do that. And it did not occur with the consent of the parties to the modification case or their counsel. Judge Amy's personal seizure of the minor children and jailing of them were acts that are not normal judicial functions and did not occur in the judge's courtroom or chambers, did not center around a controversy, did not directly and immediately arise out of a visit by the minor children to the judge in his judicial capacity. Personally seizing and jailing minor children outside of the court while court is not in session is not a judicial act. In the alternative, Judge Amy was acting as a police officer in seizing the children. And he has no judicial immunity because he's not a police officer. He has no police powers, but he was acting as a police officer. Judge Amy was acting as a prosecutor in seizing the children. He doesn't have the authority for that. Judge Amy's conduct is clearly not contemplated by his judicial role. He acted in clear absence of jurisdiction in personally seizing the children. And the same thing with regard to the pickup order and that litigation.
What about abusing the court power? What about abusing the power of the court? Jeff, if you or I did this as officers of the court, we would be sanctioned for that.
We'd be dead.
If we were abusing the authority and power of the court.
Yeah, we'd be dead. I mean, essentially, we'd be dead. And so here's what he's asked. He said the children have nightmares. They've suffered injuries to their wrists. They distrust the legal system. They want... They brought 3 claims against him. They want they pray the court enter a judgment for Fourth Amendment unreasonable seizure against the judge and award actual and punitive damages.
Can I? The chat came up with a good question, and I've wondered this myself. They're saying, please tell me he's going to prison. No, he's not, because he's not being charged criminally, although I believe he should be. Why is it? Who would charge a judge with a crime if for deprivation of rights and all the things that he did here? Why can't he be charged with a crime? And if he could be, who would do it?
That's a good question.
The Attorney General, probably, except he's the one defending this guy.
Right, because they defend the state.
Yep.
They defend this. Isn't that sick? Who would
the DOJ could investigate and hold him for criminal contempt or criminal whatchamacallit, conspiracy.
The Federal Department of Justice?
Yeah. That's where I think I think that would be the person, that would be the entity to pursue criminal charges against him.
That's what should happen.
Yeah. For criminal conspiracy to kidnap, fraud, duress, torture, all of those things. I think that would be under the auspices of the DOJ. But
sounds good to me.
I want all of those things. All of those things.
If they can make up charges, if the state can make up charges to get rid of Section 230 before the Supreme Court, where even the Supreme Court is going, wait, what crime was committed? Huh? I'm not getting it. I don't see why they couldn't come up with a case against this guy.
I don't either.
Well, this would be a federal crime, wouldn't it?
Mm-hmm.
It'd be a state crime.
No, it's federal. No. It's crossing state lines. He's operating, he's colluding with people from other states. They're exercising authority in other states, right? So he's telling his co-conspirators in the state of Louisiana to kidnap the children and to hold the children indefinitely.
Yeah. Well, the second claim is for violation of their First Amendment rights. The third one, so they want him to enter a judgment for First Amendment retaliation against defendant in his individual capacity. So they're not going after the state; they're going after the judge personally. And defendant Judge Amy's pickup order directly and proximately cause the seizure of plaintiffs' children. There's more violations of our amendments here under the due process clause. So unreasonable seizure, which is a civil way of saying kidnapping, First Amendment retaliation, and due process under the 14th Amendment. And they don't ask for the money in this. They don't say exactly how much they want. They just say we want actual damages and punitive damages against the judge personally. So what does the judge do? Does the judge answer these? Does he say fight it? No. The first thing he does is I assume, I haven't seen the exact document, but I'm assuming it's a motion to dismiss based on judicial immunity. And he lost.
He lost.
And it was appealed.
And the attorney general of the state appealed it for him. Instead of saying, you know what,
Yeah.
we're not gonna waste taxpayer money on this. We're not gonna do that. You go get your own lawyer if you want to appeal, but we're done. Our obligation to you is done. But no, the attorney general of Missouri, whose name is Andrew Bailey, by the way, and he's on Twitter. And you are welcome to go on Twitter and tell Andrew Bailey what you think of him, because I've been doing that for the last several days. I think he's a total asshole for spending taxpayer money. And I think hashtag due process now should flood his Twitter account for due process for the Rocket children, because this is simply denying this family their due process and continuing the abuse instead of letting them get their day in court. So he's taken it all the way to the circuit court, to the 8th Circuit Court of Appeals. And this is Andrew Bailey's doing. Just letting you know. I'll give you his handle here in a minute.
And so that's the important thing, what Megan was saying. He doesn't pay for his own lawyer. This judge doesn't pay for his lawyer. All you people here in the chat that are in Missouri, you are paying to defend this guy in court. Your tax dollars are paying to defend this judge in this civil case. How's that taste?
Sickening. I'm dropping his Twitter handle in the chat for you guys. I think that he should have a bad day today. That's what I think. I think he should be hearing from the people about what you think about the state of Missouri paying to defend this man in his now, second appeal or first appeal on the first loss. So twice now, motion to dismiss is being argued and wasting not only the people's money, but Bart Rocket's money too, because this is costing him a fortune. They are dragging it out. He still has to go to trial, you guys. He still hasn't got the facts put before a jury and a judge. That's wrong. In this country, we should not be fighting, the taxpayer money should not be fighting against the people and the people's right to due process. And that's what Andrew Bailey is doing right now.
Any comments before we get to the appeals, Dani?
No, I'm just playing with the chat, and they actually do have good questions. So if he loses immunity, why can't he be charged? The answer to that is I don't think he can't be. I think he absolutely can be charged criminally outside of the scope of immunity, where he's acting outside of the scope. And then why are the sheriff and jail getting a pass? That's my question. That is my question. How the hell did they get a pass when they didn't have to Megan's point earlier, they don't have an order from that state telling them what to do in their jurisdiction. They have it from some no-name judge who they don't even know is a real judge. For all they know, this could be a completely fraudulent order coming from a different jurisdiction, a different state, and they're just kind of following it. Nah, that's well outside of what they should be doing, their general operating procedures. That's why I said, I was willing to give them a little bit of the benefit of the doubt before, because I've had officers enforce protective orders in jurisdictions where they probably shouldn't, where the jurisdiction has not adopted or otherwise created a protective order in that jurisdiction. And I'm really grateful when police actually do that. However, in this situation, this is such bullshit. This is such bullshit. One of the first things that cops will tell you when you call the cops because you've been denied parent time is, this is a civil matter. Go back to your judge. And there's nothing we can do. Even if the judge issues an order, we can't force your kid to come and see you. That is one of the first things the police tell you. And that's national. It doesn't matter where you go.
Yeah,
Every
this judge is
freaking
just
cop
totally
should
rogue.
know this and be saying this.
Totally
So
rogue.
for them to go against their own intuition, their own experience, and say, yeah, I'm going to follow this order from out of jurisdiction that we have no way of verifying whether or not this is a lawful order is just beyond me.
And so what we're going to do now is we're going to clear off the super chats and other comments. And then, as I said, and again, the immunity deals only with the civil claims. There was never any criminal charges, which we've been talking about. So there's the issue of whether or not he has immunity for criminal charges is totally separate and irrelevant because no criminal matters have been filed yet.
Can
Okay.
I also just point out that this judge, Judge Amy, is still sitting on family court making decisions today. And I have information that he is screwing around with another family, a father who's having problems with him right now, who didn't know about this lawsuit until I did a stream on it the other day. And I mean, there are still families suffering in this man's court for years now after this happened. And no one has, his chief judge did not decide to put him on traffic tickets. This is it's absolutely unbelievable that this man is allowed to continue doing this to families.
It's unbelievable to me that he even has a license to practice law, period.
Oh, and he will keep it. Believe me, he will keep it. It's
Well,
Missouri. It's the doorway to hell, Dani.
It is hell, honey. I wouldn't call it the doorway. I call
That's
it hell.
the fifth level, at least.
Okay, so what's going to happen? As he said, he appealed this. He made a motion to dismiss. It was apparently denied. Then he made an appeal to the appellate court. The appellate court dismissed his appeals. Now this is before the Supreme Court of Missouri, correct, Megan?
It was appealed. Wait, the first one, yeah, the first appeal was the first motion to dismiss was heard in the district court. The district. I don't know technically which court that is. But
that's the lowest court.
The lowest court. Okay, so it had to have gone then to the Supreme. How could it have gone straight from there to the
because you go
court?
to you go from the district court to the appeals court to the Supreme Court. So has it been appealed once or twice?
It's been appealed once. So now we're in the circuit court. Okay. We're in the circuit court. That's where these arguments are that we're going to hear. So the next step is the Supreme Court of the United States, you guys, of the United States, not the Supreme Court of Missouri. If Andrew Bailey of the Missouri Attorney General, he's the Attorney General, if he decides to appeal again after they lose this, because I believe they're going to lose, it will have to go to the Supreme Court of the United States.
I hope it does.
I hope it doesn't.
Yeah.
He needs to stand down. Stand down, Andrew Bailey. Stand down and let this family get their justice.
I hope it does, because we need this kind of precedence. We need the Supreme Court to hear these kind of cases. They need to know what's going on in family law. Family law is one of the most highly neglected, in my opinion, Supreme Court areas of law. And there needs to be some kind of consensus here, especially if we're all signed on to the UCCJEA. If all the legislators are basically following the same law, there's no reason that the federal court can't step in and say, wait a second, here's a deprivation of rights going on with children. We should not be allowing jurisdictions to exercise that kind of authority over minor children in the ways that they do. There needs to be additional guardrails that are put in place either by the legislature or under the law as it exists today.
Well, let's listen to the appellate arguments from both sides. We're going to listen to the audio from the appellate court. But first, let me burn through these real quick here. Anakami says, I think there's, we already did that one. You get a twofer from that one. Trent Thorough said, and people on the right still back the blue. Dragon's Treasure, this is why I do not wish for peace.
So do people on the left.
Isaac Bruce Wholesome Gabagool Art said, exterminatus us, the penalty for California, but Missouri is now close second. My grandparents love going to Branson. Thanks for covering this. You're welcome. And thanks, Megan, for bringing this to my attention.
You're welcome.
Danny probably isn't thanking me for ruining her 6 o'clock a.m. wake up call there.
No, I'm fine with it. The snow is still falling outside. So again, I'm just grateful I have internet. And Megan, you are the bomb, and I love you and thank you.
Thank you.
And Meggles says, thanks for ruining my night with this case, Jeff. No wonder people don't trust the law enforcement / judicial system. This would be unbelievable as a movie plot.
I guarantee you eventually this will become a movie. This is it's that big.
4-door more corgi became a YouTube member.
Great screen name.
Nice. That was funny. Flux. Hey, Flux. Thanks, Megs.
Hey,
I'm going to make him cry. You tell him Megan sent you. Don't tell him I sent you.
Yeah, you tell him I sent you. Go ahead and tell him I sent you and make him cry, Flux. Go ahead.
Dyer Morales says, missed the beginning. Why are these children picked up because they didn't want to go with their mother? The
That's
end.
it. It's a child custody dispute.
Kyle Cowden. I had a chiropractor from no area. Northern Ontario, somewhere. He said, we don't allow corruption in our public officials. We demand it. Yeah. And chaos coordinator, they need Steve there or Kurt. No, see, you've got this wrong. The good guys are winning. The father is winning. The Missouri court said the judge does not have immunity against this suit. Now it's gone to the federal circuit court. The federal circuit court is hearing whether or not the judge should have immunity. And that gets us to where New Orleans. Okay. Against his New Orleans. All righty. Gotcha. Thanks for that. So that brings us up. We're all caught up with all of this. Now we're going to play the audio from these arguments. And spoiler alert, the circuit court sounds like they are having none of it. None of it. And I told Megan I was stealing her comment that they're attorney general's flying monkeys.
Yep.
Because he's definitely got flying monkey vibes.
You got to give this guy credit, though. You got to give him credit for having conviction while he makes this terrible, ridiculous argument. He's selling it. He's selling it as hard as he possibly can, even though it's absolutely bullshit.
Chaos. The children are with the father. The mother has no visitation rights whatsoever right now because the Louisiana courts seem to have their shit together.
The Louisiana court
they
took a look at it. They looked at the history and they saw her involvement in what happened to the children. And they said, nope, no more. You're not doing this to them anymore.
I wish we could just make this little window tiny here. So that we could be big and it was tiny, but it only lets one of us be big. Whatever. So, all right, you get to stare at this nice little blank screen here. And
you know what you can do? You can just change the view. If you can leave it up on the screen and go to your change view and go back to just the three of us, and we'll hear it in the background.
Will we? Because sometimes it works and sometimes it doesn't.
Oh, it works for me. I don't know.
All right, we'll see if that works. Here is the live recording of the appellate court arguments. Here we go.
Case number 21-390.
Oh, and by the way, the audio is only in one ear. It's not your fault.
Right.
03 from Western Missouri, D. Bart Rocket et al. Versus the Honorable Eric Imey.
Mr. Talent, when you're prepared, please proceed.
Oh, good. We can do that. Wait. Yep, we can still hear it, can't we? I can still hear it.
Yeah, I can hear it.
All right.
They're shuffling.
Okay. Now, Dani, question for you. Dani, are you with us?
Yeah, I'm here.
You've got 10 minutes in front of the court or 15 minutes in front of the court. How prepared are you when the judge says go?
I'm speed running. I'm ready to go. That's how prepared you are. You're speed running. That's what it is. Especially if you only have 10 minutes. You're like, how do I maximize every single fact I have? How do I arrange the facts and arguments in a way that is effective and persuasive? And then you practice that shit in the mirror every freaking day for at least 2 or 3 days before the hearing. That's how you do that.
And this is a minute of the attorney general, the assistant attorney general, just shuffling papers.
My sister does appellate law, and she was in front of the circuit court. She was told, just go stand in front of the podium if you're the first one up. Just go stand there. Don't go to counsel table. Yep. Go get ready and wait. And as soon as they say, call your case, you go. That's how it works. Or you piss off the judges.
Lights.
Good morning, Your Honors. May it please the court, Michael Talent.
Yeah. So, all right, here's this guy, and he just sounds so damn unprepared too.
And I represent Judge Ahn in this judicial immunity appeal. This case stems from an underlying custody dispute in Taney County Circuit Court in Missouri and involves 2 acts by Judge Ahn. Each act implicates a different part of the judicial immunity analysis. The first act, and therefore the first part of the analysis, is whether Judge Ahn engaged in a judicial act when in October 2019, he escorted the children, who are the plaintiffs here represented by their father, down to the detention holding area or detention area of the courthouse in order
either of you have comments, just
to
interrupt
detain
me.
them for an
Tell me
hour
to stop.
because the children had refused to comply with the custody agreement that the parents had reached that day and that Judge Amy had approved, and that all agreed on the record was in the children's best interest. The second question in a subsequent proceeding in the same custody dispute is whether Judge Amy acted in the clear absence of jurisdiction, when after the children and the father had not been complying with the terms of the settlement agreement, the mother filed a contempt motion in Taney County Circuit Court, and after the father and the children
Just audio, there's
didn't
no
show
video.
up, Judge Amy issued a pickup order that resulted in the children being detained in Louisiana by Louisiana deputies. The first is a judicial act under square precedent from the Supreme Court and this court, and the second was an act done under the subject matter jurisdiction of Judge Amy, and so therefore was not done in the clear absence of jurisdiction, and he is entitled to judicial immunity for both acts. Turning first to the October 2019 detention, the question there is whether what Judge Amy did was a judicial act. This is a functional analysis. It looks first to whether the act relates to an action or a function normally performed by a judge, is a language used in, for example, Stump v. Sparkman and Justice Network. Judge Amy in his briefs provide three examples of normal judicial functions that relate to the act he did here. The kind of
So, spoiler again alert, keep your eyes open, because what he's going to argue is it's not really a question of whether the judge has the legal authority and jurisdiction to do this. It's more of a question of do judges do it anyway?
Yes.
That is
And by
literally
the way,
his arguments.
Stump v. Sparkman, by the way, was a 1978 Supreme Court case that gave us judicial immunity over a judge literally forcibly sterilizing a woman. If you want to get mad about something, read that case. The Supreme Court ruled that the judge who forcibly had a woman forcibly sterilized against her will was given immunity on that case because, and this is why, Dani, I disagree a little bit with you on whether this should be heard at the Supreme Court level, because I believe the Supreme Court will protect their brethren in black robes. They will protect them. They did it in Stump v. Sparkman, and that's why we have the type of terrible judicial immunity that we have today. It was over the forced sterilization of a woman, and the Supreme Court said, yeah, that's fine. Because he was acting in a judicial capacity. But in that case, there was actually an order that the judge made an order so they could actually make that argument. In this case, there is no order.
Yeah, I said, he sounds very amateurish to me. This is one of these state attorney general's right-hand men. Yeah, he's not all that amateur.
He's nervous because he doesn't want to actually tell them what this judge did, and you can tell because when he gets to the part about taking the children to the jail, he starts stuttering so hard that he can barely get the word detention out.
So those of you that a couple of weeks ago watched Steve Gosney doing his appellate arguments in an amazingly calm, cool, collected, polished manner, this ain't happening with this guy.
Yes, Steve is great. Steve is great.
That.
And not every oral argument is phenomenal, okay? Like I've done oral arguments where I stutter quite a bit and I still win them because I have good arguments. But this guy is high in the sky, so he better be a silver-tongued
serpent?
Something
serpent of the court. Yeah, I mean, he better be very, very verbally persuasive. Otherwise, I don't think he's going to get very far here. So,
yeah. So these are not Gosney-esque arguments, but like you saw with the Gosney case, the appellate court judges, they will interrupt you, they will question you, and they will hammer you on the points that they think are important, and that's what happens here. And Guy doesn't really know how to act. But like I said, keep your eyes open, and y'all gave me shit for it. Keep your freaking ears open. Don't care what you do with your eyes. Keep your ears open, all right? Keep your ears open for this beautiful argument that it's not really about whether the judge has the legal authority and jurisdiction to do this. It's more a matter of, well, do they do it anyway? Watch for that argument.
High-level question of the high-level act we're looking at here is whether it's a normal judicial function for a judge to order individuals who are defying or thwarting the efficacy of a judicial order,
was there an order in place? As I understood, this was a consensual agreement between the parents.
Right out of the gate.
And there really was no order in place.
The judge had approved the order.
So that was the case. He's like they were disobeying, you know, an order. He said, well, was there an order in place? There wasn't an order in place, was there? Well, he approved
For that day, and that's in the record. Now, I think Mr. Rocket quibbles about whether it was denominated a final judgment under Missouri law, but everyone, I think, agrees that was the operative complaint and the operative kind of custody arrangement entered in court at that time, and everyone had agreed on
Were
the
the children parties to this agreement?
The parents are parties to a custody agreement. The children are kind of in Missouri, they're subject to the in rem jurisdiction of the court. So the children were there, and as part of the proceeding, they weren't parties to the proceeding, as it were.
yes, literally, that's the answer.
The answer is no. Like, if I were that judge, I'd be so pissed. Like, just tell me yes or no. I mean, what? Oh.
Well, sometimes, yeah, but well, the parents were the parties, and the children, you know, in rem part of the. Yeah.
So they're subject to some jurisdiction that I need to come up with right now.
Yeah. So, what
Isn't
do you
it
think,
great,
Danny?
though,
Does he know
how the judges get right to the heart of the matter, which is,
yeah.
hey, wait, I thought there wasn't an order. There's no order here. And also, were they a party to the case? These guys know what's up.
Danny, do you think the
I
guy's
have
fucked
nothing
yet?
to add.
Do you think the guy knows he's fucked yet? The Attorney General, Flying Monkey?
Not yet.
He should have known he was fucked the minute he picked up the file and read through the complaint. Like, that should have been the moment where he went, shit, let's settle this. And let's just settle this outside of court. We'll pay you your $3 million. Please go about your day. Have a nice one. That's what should have happened.
Danny, so here, there was a question in the chat that was like, doesn't Megan know that the Attorney General is obligated to defend this guy? And if he didn't do this, the judge could say ineffective counsel. I don't think he was obligated to appeal the ruling from the district court.
Correct. So the AG is not obligated to defend this person personally, first of all. Second of all, whether or not he decides to defend the judge is really a matter of defending justice and determining what's in the best interest of justice. This is his role, just like a DA, just like any other prosecutorial arm of the state. Their role is to look at what is just, not try and defend the acts of a really, really bad judge.
Yeah, and it's not really even this appellate lawyer's problem. It's the Attorney General's problem.
The Attorney General's problem. And it's all political. Like, if you don't think it's not political, think again. It's all political. Everybody knows everybody. Everybody's greasing each other's palms. Everybody's everyone's friend. And that's what they're doing is they're trying to provide coverage for their friend. And that's why I actually do agree with you, Megan, at least with your concern about, you know, men and women in black robes protecting others in black robes.
I would like to think that this Attorney General got this case assigned to him and just went, oh, shit.
But obviously he didn't, because if he did, he would have found a way not to do it. He would have said, no, this is not in the interest of justice. You go get your own attorney.
He would have settled. He would have settled. He would have said, either you guys agree to settle or I'm calling in the DOJ to perform an investigation here.
There it is.
I don't want to tick you off, family and friends, okay? I know you're my buddy, but you effed up. Go get yourself an attorney. We'll talk.
The chances of that happening, though, are virtually nil, because as soon as he tells his boss, the Attorney General, he's not going to go ahead with this case, the AG is going to fire him.
Yeah. And that's
he's going to lose his job.
Gosney. It happens all the time.
And the chances of him willing to put his life and career on the line,
he's
going to slog through it.
He's a Republican.
He's a flying monkey.
Andrew Bailey's a Republican. So are all the legislators in Missouri, mostly who are in control. They're all Republicans. And I'll tell you what, they are the most spineless Republicans. They are the least freedom-loving Republicans I've ever met in my life, because they don't have the balls to stand up to the black robe mafia in Missouri.
Yep.
You repeat yourself when you don't need to say spineless and Republican.
That's true.
You just say Republican. That's my only singular complaint with my own political party.
That's what we're all bitching about, Jim, is the fact that they're required to defend the state officials in civil matters, and they shouldn't be that way. It's shitty.
I thought the Attorney General was supposed to be the people's attorney, but it turns out he's the state's attorney. He's the state's flying monkey.
Yep. All right, let's get back to these awesome arguments about the order, the existence or not of the order.
Is it ordinary for judges to issue I assume the judge considered this contempt? What is the judge's authority and basis for seizing the children?
So Judge Amy does point to the contempt procedure. It's a normal function, a normal authority of Missouri judges to be able to hold individuals.
So is that your position, is that this was a contempt action?
Judge Amy didn't denominate what authority he was operating under. It is the question for immunity.
How shitty is that?
There is
he
no
can't,
authority.
Yeah, he cannot say yes, he based this on the contempt because the children cannot be in contempt because they had nothing to do with the original order.
They weren't even in the
There
weren't
wasn't
even in
even
the
an order.
courtroom. They were in the hallway. They're not a party to the case. You can't hold someone in the hallway in contempt. You're no longer a judge in the hallway.
There was no order, and even if there was an order, the kids weren't a party to it, so they couldn't be. And now he's just like, well, fuck. What do I say now?
Here's the scary thing, Jeff. If he had been smart enough to write a contempt order, he might have retained his immunity on this.
Could have been. That's what I'm saying. If he would have just said, "I did this yesterday," but this is the thing. What this guy has just said is, the judge in arresting these children never said why or how he had the authority to do it.
Immunity purposes is less about whether he exercised an authority lawfully given and more about whether what he did is something judges do.
Well, how frequently
there you
in
go.
Missouri
Listen
or any
to
other
that
state
shit.
that you're familiar with?
Oh shit! I backed up too
Whether
far.
the
God damn it.
judge, whether it's not about whether he had the authority, but whether he did what judges do.
Hold
So is
individuals.
that your position is that this was a contempt action?
Judge Amy didn't denominate what authority he was operating under. The question for immunity purposes is less about whether he exercised an authority lawfully given and more about whether what he did is something judges do.
But no, that is
What do you think of that shit, Danny?
that's made up. This is a made up legal standard. This is upon information and belief legal standard. That is what this is.
On what legal authority did the judge throw these two children into jail twice?
He just
Well,
said
it's not
none.
important. It's not important whether or not he had it. It's something that judges do. So let's move on. That was his fucking argument.
Mm-hmm.
So I guess if judges stand up and take a shit in their black robes right in front of everybody, and that is the commonplace. This is common procedure for judges when they start a courtroom proceeding. Don't make it lawful. Don't make it okay. All right.
You
I
know
don't want to
his-
see your shit. Your shit stinks. Stop it.
You know his argument is shit when the only argument he can come up with is, well, there might not have been any authority, but it's what we do. It's what they do. So
And remember what your mother told you, Megan, and I'm sure Danny, what your mother told you, because my mother told me, well, if all the other lawyers jumped off a cliff, would you join them?
Exactly.
Well, I mean, there is some I think he's confusing industry standard with legal immunity, with judicial immunity. That's what he's doing. He's confusing two different legal principles.
Yep. Let's see how well that goes for him.
Well, how frequently in Missouri or any other state that you're familiar with do judges take people to holding cells?
Very frequently, sir.
Well, in this case, this relates to the seizure issue. The question for immunity purposes, Judge Smith, isn't really an empirical question in the sense that, so looking at Stump v. Sparkman, that was a petition for sterilization. And I think the dissent there argued this has never been done before. What the Supreme Court said is, even if a petition is passed on only once, that doesn't vitiate immunity. What matters is whether it's a function normally performed by a judge. And judges do normally engage in what may be termed a seizure under the Fourth Amendment by a show of authority.
They do it, but not this.
They
I
regularly
think this judge had
kidnap
a
people. They regularly kidnap people, is what we just heard.
Yes.
Judges regularly, illegally kidnap people, and that makes this okay.
Keep going, Jeff. I'm going to shut up. I can't. The stupid is overwhelming. My circuits are breaking down.
But
Jim
it's
Satala
funny.
says that argument is beyond retarded. So since judges normally sentence people to prison for 20 years, if a judge just does it to someone who's not before his court or charging, it's okay. I mean, this is just retarded.
But I think the admission, Jeff, the admission here, everybody should sit up and pay very close attention to what the Attorney General's flying monkey just admitted. He admitted in front of the circuit court that judges regularly throw people in jail without authority. That's what he just said. And that's true, by the way.
Yeah.
I was going to say, well, it is true. So
yeah,
he's not wrong,
He's not wrong.
it is mind blowing, and everyone should be repeating this. They should put this on an audio. This should be my ringtone. Like my old ringtone used to be "How Dare You" by Greta Thunberg. This is my new ringtone. The judges regularly, as part of their office, do this.
By the way, in Missouri, I have had people in Missouri and in other states get thrown in jail on contempt for talking to me, for going to the press.
Nice.
There have been judges who have thrown parents into prison, into jail on contempt for talking to me.
Flying monkeys were at least cool and cute. You know, I feel bad for the flying monkeys now. Popcorn Power says, does this AG lawyer really have much of a choice? He's got the choice to do what he's doing or lose his job, basically. It's up to him to decide where his moral character sits. Now, let's get back to more fun in the courtroom.
A little bit of black robe disease and thought his power was maybe a little bit more than it actually was. And usually when you do something like this in state court, I used to be a state court judge.
You got to back up a little and hear this because this judge goes off.
This thing is so tiny, this little bar. All right, I got to go back like about a minute, it looks like. No, there you go.
In the sense that, so looking at Stump v. Sparkman, that was a petition for sterilization. And I think the dissent there argued this has never been done before. What the Supreme Court said is, even if a petition is passed on only once, that doesn't vitiate immunity. What matters is whether it's a function normally performed by a judge. And judges do normally engage in what may be termed a seizure under the Fourth Amendment by a show of authority.
They do it, but not this way. I think this judge had a little bit of black robe disease and thought his power was maybe a little bit more than it actually was. And usually when you do something like this in state court, I used to be a state court judge, you actually go through some procedures. You don't walk into a conference room, you don't throw two kids into jail, make them take off all their shoes, put them in a holding pen, and then when they come out, tell them they're going to go to foster care if they don't listen.
So two answers.
If somehow this AG did not, this AG lackey did not know that he was fucked, he should now.
He should now. And by the way, it's so common for judges to overstep their authority that there is a term for it, black robe disease. And the term is so well known. This is not just something that judge just made up. Black robe disease is a term that is very well known by judges all over the place. They know what it is. Black robe disease exists. It should be stamped out wherever it is found. And they do a very piss poor job of doing it, by the way. I'm proud of these circuit court judges for calling this shit out for what it is. And I have a very good feeling. We don't have a decision on this yet, by the way. We're still waiting for the decision to come down. But I have a very good feeling that this guy is screwed.
Yeah. What do you think, Danny? Is the federal court buying any of this?
I'm shocked that I'm shocked that the court didn't say, yeah, he's got black robe disease and it's terminal. Let's put him out in the
Answers to that, Judge Strauss. The first is judicial. This is where the context matters. So the court was over. The father was out of the courthouse that day. He had already gone, and the complaint says he couldn't get back in. So they're there in the courthouse with the mother, and they're not complying with the custody arrangement that Judge Amy had pointed out. That Judge Amy had approved that day, that everyone was agreed was their welfare. So I think the analogy here, if we want to draw like a process analogy, it's almost like a motion for reconsideration. The children approached Judge Amy and said, we don't like this custody agreement. They knew he was a judge. We don't like this custody agreement, and we don't want to go home with our mother today. And so Judge Amy was presented with a situation where the children were not complying with an order that was entered for their welfare. And
it wasn't entered. That's the whole point. We already went over that.
Now, you just yelled over the judge saying exactly the same thing.
Oh, sorry.
Yeah, the judge said the same thing. There was no order. But he's that judge is hard to hear. So it's fine for you to just keep going, Jeff, because we wouldn't be able to hear it very well anyway. But that is what he said. He said, wait a minute, there was no order. And by the way, that the AG's a flying monkey just lied. He said that the children approached the judge. You will hear later on that one of the judges calls him out and gets him to admit that he lied about that. At that moment, I would have held him in contempt. I would have held him in contempt for perjury. You just lied to my face, and you know it. I'm disappointed that they didn't, because the AG's guy just lied to the circuit court judges. The children never approached the judge. He approached them. It's bullshit.
The argument from AG's guy would be, Your Honor, I apologize, I misspoke. And then they would give him a little, yeah, well, don't do it again.
Well, he didn't even do that. He just admit. You'll hear how he does it, and it's so snaky.
All right. Well, now, see, Danny, you're thinking like a federal court of appeals judge.
Ew.
No, the circuit
hope
court
not.
judge.
Circuit court
Judge. So, all right. Listen to him jump on literally the exact same wording you just said.
Consideration. The children approached Judge Amy and said, we don't like this custody agreement. They knew he was a judge. We don't like this custody agreement, and we don't want to go home with our mother today. And so Judge Amy was presented with a situation where the children were not complying with an order that was entered for their welfare. And
It's not a motion for reconsideration. I mean, there was no hearing. It was the non-parties that were objecting to this. I mean, it doesn't look anything like a motion for consideration. I mean, that would be a judicial activity, a judicial function. And there are, as Judge Strauss indicated, procedures that go with that. And an order would issue, right? An order would issue following that motion for reconsideration.
Correct.
And then it would be enforced presumably by an executive official, police officer, deputy, something along those lines.
And the point for judicial immunity in this case is that procedural problems, grave procedural errors don't vitiate an act's judicial nature. That's City of Haytop.
Analogizing this to a motion for reconsideration to suggest that it was a judicial sort of function, because on its surface, it just doesn't look like.
Well, the children approached Judge Amy as a judge. They knew he approved the custody agreement. They knew he could release them. The authority, and this is the authority he used to seize them, to quote unquote seize them, was his judicial authority. Mr. Rocket agrees to that in his brief. So they approach him as a judge. They ask him essentially, they debate about the validity of an order. They don't want to comply with it. And when they continue to refuse to comply with it, Judge Amy walks them down to the detention center and orders uniformed officers to take them into custody. That's very similar actually to Newman v. Indiana. The judge there, that was a seizure. They sued for temporary deprivation of liberty. The Seventh Circuit noted that, and it was a midnight hearing in the judge's chambers. And the judge, after the hearing passed, said, I'm not going to grant your motion, your extra hearing, and you need to stay in my chambers until the sheriffs are done picking up the child at your house.
Now, my understanding, though, and correct me if I'm wrong, is the judge walked out from chambers. He didn't have his robe on, and you're saying that the children actually approached him. I thought he approached the ensuing discussion that was happening in the courthouse lobby. Am I wrong about that?
I think that is correct, but the engagement with the children and the reason they followed him was because he was a judge. And so the authority he exerts, even under Mr. Rocket's reading of this case, is his judicial authority. And when they don't comply.
So the reason the children followed him was because they appreciated and fell within the penumbra of his judicial authority. It's just a Pied Piper. Oh, my Lord.
He lied 3 times to them, saying the children approached the judge. The children approached the judge. The children approached the judge. The very first time he's taken a task on it, he says, oh, yeah, I think you're right. The judge, I thought that the judge approached the children. Yes, you're right about that. What?
It was you're right about that, but they understood he was a judge, and therefore they followed him because of his judicial authority.
This is so deeply concerning that he's citing to other similar cases. It's like, if you live in Missouri, hide your kids, hide your wives. They're kidnapping everybody up in here.
Right.
Yep.
Right.
Comply with an order entered in for their welfare and tell him multiple times that they're not. The detention itself is functionally akin to a contempt hearing, the individuals refusing to comply with the court order or otherwise thwarting judicial process. It's related, you brought up foster care, Judge Strauss. It's related to the authority of the Missouri circuit judges to take children into custody when it would be in their welfare.
I'm thinking that actually this doesn't fall under any government authority at all, which is an executive officer has to, an executive official, a police officer has to have at least probable cause or reasonable suspicion to stop and seize someone. He clearly didn't have arguable probable cause or arguable reasonable suspicion. So he wasn't using executive authority, and judicial authority ordinarily happens in a courtroom with, as Judge Kobus says, with some sort of process. So it doesn't appear that he's actually exercising judicial authority. And I don't think there's any legislative authority going on. So it seems to me like there was just no authority for what Judge Amy did.
Well, we point out.
Yeah, this is the judge saying that, like, the judge doesn't have the authority to do this. Even police don't have the authority to do this. The prosecutors don't have the authority to do this.
In other words, there's no lawful law here.
No lawful law.
No lawful law.
No lawful law here. There is no authority. And I love that he's just calling it out. And I mean, at this point, this is when the AG should have been like, you're right. I'm sorry. I withdraw. Let's just stop this now.
He's in too deep now. Now he needs to. No. I would not advise him to stop. I would advise him to continue, because otherwise he's going to get slapped with sanctions and with bar complaints.
He should be slapped with
because of the frivolous nature of this. So he needs to make an argument now. He's already in too deep. He needs to make an argument that this was not frivolous, that there is a legal basis for the reason he came about this, and that there was some kind of hope that and chance that he might win on that basis.
So Snowflake's Nightmare says, how the fuck is it legal for a lawyer to lie in court? We would be held in contempt. It's not. I mean, he can be held in contempt. And Toothless 420 says, the fun thing is lawyers can lie. It's one of the things they are renowned for. Lawyer is not under oath. No, lawyers cannot lie in court.
We cannot lie. We are officers of the court. We have a duty of candor to the court and to the record.
Yeah. We're not put on under oath when we start a case. We are under oath from the first time we raise our hands and say that we're going to be a good lawyer and please let us have our license. You cannot knowingly lie in court, and you can't. Not only can you not lie, you cannot knowingly let your client lie. If you know your client's lying,
I've turned my client before and fired many a client when they've given me their testimony, and I say, "Is that really going to be your testimony in court?" And they say yes, and I say, "Then I cannot represent you." And that's it.
Yeah. Yeah, lawyers lie all the time in court. This guy lied, but see, again, he could have explained it by saying, "I'm just confused. I'm sorry, I misspoke."
Yep, I misspoke. Correct. I apologize, Your Honor."
But he
that
didn't
is how
do
you
that.
should handle it.
He said
no, he didn't do that.
He basically admitted that he lied, because the judge said, "Well, wait a minute. I thought that he approached the children." He says, "Yes, I think you're right on that point," but that doesn't explain why he
tomato.
Shaster lawyers.
3 times he said that the children approached the judge. The children approached the judge. The children approached the judge.
Yeah. I mean, sometimes what people think is a lawyer lying is not really a lawyer lying. Take a criminal case, a murder. If I ask my client to tell me, did you murder the guy? Yes. I cannot get up and say my client did not commit that murder. I cannot do that. But if I know deep in my heart of hearts that he murdered someone, and I don't ask him and he doesn't volunteer that information, I still have a duty as his lawyer to believe him. And I can get up and argue he didn't commit the murders, even if I'm like 99.9% sure he did it. I'm still not lying because he has not definitively told me he did it. And there's no pictures of him doing it, et cetera, et cetera. It's some people would call it a technicality.
But this is why lawyers always say, "I don't want to know."
Oh, yeah.
So when you guys see this in movies and you see the attorney say, "I don't want to know. Don't tell me these things." That's why.
That's how it really works, too. And some of you that have been watching my O.J. Simpson trials on Thursdays, that was one of the things that F. Lee Bailey said. He said, in all my 50 years of practice, I have never asked a single client if they did it. That's for exactly that reason. He doesn't want to know. As long as he doesn't know, he gets to be a lawyer. All right, let's continue with this shit show.
Now in Missouri law, he is allowed sua sponte to do contempt. He is allowed to order ex parte. This gets to the Forrester v. White, I think, at the end of the day, the informal and ex parte nature of a decision, of a court decision doesn't render it without immunity. Courts routinely issue ex parte orders. Mr. Rocket cites Lopez v. Vandevader out of the Seventh Circuit. That the court there noted plethora of orders that are issued by judges, not within the courthouse, not in the context of formal procedures. There could be ex parte motions, emergency motions, judges have to rule on at their house.
There are orders issued.
Well, there was.
See, you just went this. These orders are issued here. They can do this. They can issue these orders out of court. They can do this. It's like, and I love just that one statement from the appellate from the circuit court judge. Yeah, but that's when orders are issued.
That's when you have an order, a lawful
no
order
in this case.
issued with the seal of the court on it.
Yeah, there was no order in this case. He's like, yeah, great. Thanks for that last 30 seconds of telling me all the times when they issue emergency orders.
I have had orders set aside because it lacks the seal from the judge.
Yep.
Years
Until you
later.
stick
And these
it.
are lawful orders, but hey, no seal on it, no deal.
Mhm.
And that was
Yep.
it.
Yep.
There was a custody agreement on the record that everyone agreed was in the
As
best.
far as for the detention of the children, there was no formal order.
Well, he ordered the uniform officers to take him into jail.
That's not how it works.
He directed them to take certain, their shoes off and the bracelet off. Is that correct? I mean,
Well, yes, he escorted them, but then I would go to.
he ordered them. They were in custody. Don't you agree?
They were in the same way the plaintiffs were in custody in Newman. The judge used his judicial authority to deprive them of their liberty. It's kind of the Fourth Amendment test. The point is, the seizure, I think, analysis here, Mr. Rocket is trying to transform what's a functional analysis into a categorical analysis. All Fourth Amendment.
You're into your rebuttal
Yes.
time. I don't know if you want to address the second issue or.
I'll address it real quickly, Judge.
So the basic thing, you've used up all your direct time. You have a few minutes for rebuttal at the end. You want to use that to continue these stupid arguments and talk about the second point? He's like, yeah, sure.
Judge Smith, and I think this one is actually very simple. Judge Amy has subject matter jurisdiction. Under Missouri law, subject matter jurisdiction is a matter of constitutional law. Child custody disputes are civil matters within the subject matter jurisdiction of those courts, within the circuit courts of Missouri. Furthermore, so he has subject matter jurisdiction, and under Supreme Court precedent, under this court's precedent, that's sufficient. Furthermore, the order he issued was to bring the children into his court for a proceeding before him. So this is really on all fours with Morales v. Waco. This was an order issued in aid of his jurisdiction in a case before him. And in that case, it is clearly order.
It was, and that is clear. Either this guy, honest to God, is fucking lying, or he hasn't fully read the brief. Because it was made explicitly clear that it was to pick up the children and not bring them to a court proceeding, to pick up the children and deliver them to their mother who was waiting at the courthouse.
Correct. Yeah, no, this guy is lying.
Yeah, either he is lying deliberately or he just hasn't read his case.
Issued with necessary jurisdiction that is without the clear absence.
One last question. My understanding is the Missouri Supreme Court mandamused most of what Judge Amy did. Was it only the second order, the first order, or both orders?
Only the second order, Judge Strauss, and only because of the recusal issue. If you read the order issue of the exhibit to the complaint, it wasn't for any jurisdictional. It wasn't because he lacked subject matter jurisdiction. It was because of the recusal issue.
Okay.
And I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, Mr. Teller. Mr. Eastwood.
Now let's hear what the lawyer for the father has to say. Once he gets his shit together too.
Chief Judge Smith, may it please the court, Hugh Eastwood.
What was that, Danny?
Oh, I was just saying I was so hopeful, and I am still. I hope he nails them.
For Bart Rocket, his next friend of his minor children. The complaint here plausibly alleges two incidents in which judicial immunity does not apply. This court should affirm the district court. The facts here are admittedly egregious, extreme, and very unusual, as they are in most of the judicial immunity precedents, which are thankfully rare. Before I turn to my argument, I want to respond to a couple of things that occurred during my friend Mr. Talon's colloquy with you, Judge Strauss. The pleading alleges that the judge approached the kids, not vice versa, and this was after any hearing or proceeding was completed. In other words, The children were not having a visit to the judge with an expectation that the judge was going to be performing some sort of judicial hearing or function. Second, there was no foster care petition or hearing before the court. That makes this very distinguishable from those other line of cases. Even in Stump, there was a petition for sterilization, after all, before the court. And finally, on the Newman v. Indiana case that we had some discussion of with you, Judge Kobus, there, of course, it was adults who were who were parties to the court's order.
I just like how the lawyer for the father is just going down, going, yeah, he's wrong and stupid because of this. He's wrong and stupid because there were orders. He's wrong and stupid because there were adults involved. He's wrong and stupid because of this. And those judges who just hounded the state for the full 13 minutes, they're just like, all right, keep going, dude.
Yeah, they have
No
nothing
questions.
to say. They have nothing to ask him. It's amazing. It's like, because I can see where this is going. I mean, I think we should all see where this is going.
Superfluous says, where was this abuse of power for the Texas father who lost his son because the mother took the child to California to trans the kid without the father's permission?
Right. And they pick and choose.
Or the court that remanded custody to the parent who was forcing the child to get a vaccination against the other parent's wishes, saying that the other parent was high in the sky.
Mm-hmm.
SLV says this goes outside legal. This is evil, cruel abuse, and anyone with a conscience or heart would put that judge in jail. He has no rights, period. It's where you need like Clint Eastwood, but what about the rights of that little girl? Anyway, I'm not saying shoot the judge. I was just like, Clint Eastwood movie reenactment there. Just in case people freak out. All right, let's get back to this show here.
Orders who were asked to stay in the courtroom while the deputies went out to seize the children, presumably because of sort of some concern about interference by adult parties to the case. Let me turn to the first incident. Seizing a person is an executive function. It is normally performed by law enforcement officers, jailers, or in the case of children, doctors in Missouri. It is not a judicial function. And
judges shouldn't
the fact that the judge said he was going to teach them a lesson or threatened to put them into foster care did not make it any more a judicial function. Therefore, Judge Imey's acts in the first incident here fall into those line of cases where judges were denied immunities for stops, for seizures, for prosecution. It's similar to Molina. This is where the judge stopped the motorist on his commute home. To Gregory, where a judge assaulted a litigant in his courtroom. To Lopez, the judge was denied immunity for holding a man at gunpoint, arresting him, and prosecuting him. But he did have immunity for issuing orders and sentences in his courtroom.
One thing that I'm a little concerned about is state court dockets are they're immense. And if you've ever sat through one where there's 30 or 40 things going on in the morning, sometimes you see a little bit of street justice where the judge does some stuff that may come close to the line or maybe even sometimes even cross it in their judicial function. And I'm a little concerned that this is a strange case, but that that we're not venturing into some of those street justice areas. We should steer clear of them, particularly since you'd like for judges to have immunity when they're doing their very best to mete out justice and to deal with very difficult situations.
Yeah, Dani?
The term street justice coming from a circuit court of appeals judge.
I know that's upsetting.
So deeply concerning. You guys, this is why courts exist, is to have a monopoly on justice, to have a monopoly on the legitimate use of force. Okay, whether that's a force against your person, your property, you name it. The fact that we are meting out, quote unquote, street justice in any fashion, in any courtroom, is not justice at all.
I don't like the way he said it either. Dani, did it bother you as much as it bothered me that he was basically saying, well, in some of these cases, because, the docket is so big, we will sometimes see this street justice in their, and if they're trying to,
what I'm talking about.
If they're trying to do their best, we just overlook it.
Do better.
No, see, I disagree with both of you. See, I think he's giving him the ultimate softball question. Don't you think we should allow the judge to mete out a little of this street justice?
Oh, I see. So you think he's teeing them up?
Yeah. Yeah, he's
maybe,
just giving.
Maybe, yeah.
So some people will say it's a really crowded court. We can't handle all this. Maybe the judges should have this little.
See, that's
do
not
some
how I
street
heard it,
justice thing.
though. I heard him say he's not asking it as a question. He's making a statement saying because of how backed up these dockets are, we will sometimes see this street justice applied by judges as if it's just a fact of law, of life. And I think that is very disturbing to me. But you could be right, Jeff.
Let's see what the answer is.
Judge Strauss, if you're getting to the second incident where
Mostly the first.
Okay,
yeah.
we'll stick with the first. Fair enough. Stump speaks not just to, of course, the function or act of the judge engaged in, and it is a functional analysis. Judges do not normally seize children and throw them in jail cells after completing a hearing over their parents' custody dispute. But Stump also talks about the expectation of the parties, and that is important here. First of all, the expectation of the.
Well, you guys could be right, because if it was a softball, he whiffed it and didn't comment on it. The answer would be no, of course not. Street justice isn't being meted out. That's why we're here.
Maybe he meant it to be that, though. You might have a point there. But
no, because he was referring to himself in the first person, talking about being a district court judge earlier, and that's what leads me to believe that my interpretation is correct.
Okay.
I agree with Dani. I think he's basically admitting
2-1.
that street justice by judges happens, guerrilla street justice. And
Screw you, ladies. I'm not going to succumb to your guerrilla street justice. I'm right.
I'm going to add that to the merch store. Guerrilla street justice.
He's got to have like a big old silver back there, you know?
Oh my gosh. I want a
Gorilla
floaty
street
balloon animal in front of my freaking yard, and I'll name it Jeff.
Nice.
It'll be a giant silverback gorilla.
Parties would be the parents' expectation. And there's no allegation that either mom or dad here expected the judge to throw the kids into jail. The kids at the time here were 12 and 14 years old. Their youth, their vulnerability meant that they were not even inside the courtroom.
Had it been suggested to the judge to leave the courtroom and visit with the children, talk to them? How did the conversation with the children arise after the completion of the in-courtroom proceeding?
The complaint alleges, plausibly, that the judge, after court was done for the day, when he was no longer acting in any sort of judicial function or capacity, took it upon himself to approach the kids in the courtroom lobby. And we know that under the precedents that location is certainly not a dispositive factor. Judges can functionally commit acts of judging from their house in the middle of the night in their pajamas, signing a warrant, for example. But here, the judge, to your point.
Stop. Acts of judging. Is this a legal term? Is this a legal term that I don't know about?
I'm sure it is.
Wait, it's funnier. I think at some point, did I miss the part where somebody says judges doing judgy things? Because that's
Not
really
yet.
funny. Okay.
Oh my God.
Judges doing judgy things.
So Burning Sensation says, wait, is the Lorax being thrown under the bus by a gorilla?
The chat says
Givner
we're
says-
female splaining to you and we should
Yeah.
stop.
Yeah. Givner says Lorax is always right. I agree
The
with
chat's
you. I'm
taking your
always right.
side.
Yeah.
I think you could be right. I can't read the man's mind, but I had the same reaction that Dani did, is all I'm saying.
All I'm saying is the argument that just the only argument he needed to make was this one.
Everything that guy just said is bullshit. Thank you.
That's the only argument that needed to be made. So let's go.
Chief Judge Smith, the judge approached the children and sua sponte decided to get into a discussion with them about the custody order. This was not done inside his courtroom during any sort of proceeding, and it was also not done with the children's representative, the GAL, or with some sort of process of a hearing before the court with the parents and their counsel present. What I hear underlying your question, perhaps, Chief Judge Smith, is this question of alternatives. That's a really important point. The judge could have done all sorts of judgy things here.
Was the guardian ad litem still present?
No.
You like that he could have done all sorts of judgy things.
It's so cute. It's just the judge doing judgy
There's a
things.
single judge out there. They need to put that on their profile. I do judgy things.
I do judgy things.
Just doing judgy things.
And it reminds me, my sister worked for several judges in Maryland, and she was real close with a lot of them. She clerked for them for a while, and she got pretty close to like two of them. Like one of them was at her wedding and whatever. And she used to call one of them Judgy, Judgy, Judgy. And
That's
made
so cute.
I know, super cute. She was like, "Oh, Judgy's here, Judgy's here," and it just that made me laugh so hard. Judges doing judgy things. It's just cute.
Wow. All right. Well, just in case you're wondering if I'm being thrown under the bus, these are my peeps. Megan and Danny are my peeps.
Ape has never killed ape, let alone an ape child.
We love you, Jeff.
I'm sorry. I just have all of these useless clips I'm finally being able to use today for some reason.
That's fantastic. I love the clips. The Vinny one is fantastic. My cousin Vinny one is great.
Yeah. All right, let's continue with the doing judgy things.
The guardian ad litem was present during the courtroom proceeding that day when the parents entered into this sort of consent order, but no.
I just wonder whether, and this gets back to my question, whether the judge was doing judgy things when the judge came out, pulled the kids into the conference room. So far, so good. I've seen judges do things like that, and that seems judicial. I just got to be clear from you where he crossed the line. Did he cross the line later when he put him in jail? Where was the line crossed in your view?
The line was crossed when he took them into the conference room without the GAL and without the parents, I believe.
Basically, right at the
but certainly the gravamen of our allegation is that is the seizure itself, and I don't think the seizure started until he sort of dragooned, to use the word from Zarcone, the coffee case, dragooned the kids down to the jail cell, had them take off their shoes, had the boy take off his religious bracelet, which he had made a promise not to give up, and put them in these adult cells where they were sort of terrified because, of course, there was no boundaries to what would normally be considered an order. So I hold you in contempt, I'm incarcerating you for an hour, something of that nature. And there was no criminal contempt because there was no disruption of any judicial proceeding. That might be a different case for a different day, but here court was ordered over for the day.
Well, and you see what I'm saying? Family law is just a different thing. I mean, for those who have never done family law, there's so much informality, so much many parties get together, they try to figure it out. And so it runs a little differently than other types of judicial.
Stop. Here's a circuit court judge admitting family court is different with so much informality, which means he knows damn well they're holding secret hearings. They are doing bullshit they shouldn't be doing. Yeah, you mean corruption. Don't say different. Say family court is a fucking cesspool and it needs to be cleaned out. It bothers me to no end that these men know these judges know what's going on, and they are covering it up by using words like it's a little different, it's a little informal. No, it's a crime, and people's constitutional rights are being violated every day in these family courts, and the law doesn't exist in family court, and it's time for these judges on these high benches to start outing it.
Yep. I am your hype girl, man, like all the way, all the freaking way. And it's not just family court. I've seen it in family court, and there's one other court where I've seen it just so bad, and that's in immigration.
Oh, immigration. I was going to say dependency court.
Dependency is, well, and dependency is kind of family court adjacent. So, I mean, that makes sense. But yeah, no, family court is whenever an attorney, a litigator says, oh, well, you're just a family court attorney, you don't know about litigation. I'm like, I literally had 7 hearings this morning dealing with X number of many different issues. So go F yourself.
I need to have you on, Dani. We need to have a family court stream. You and I need to get into it. Let's get into it.
Let's do it.
I told you two need to get together. I told you.
I just need a glass of wine.
Oh yeah, we'll have several. You and I could get into so much. I got to invite you on the stream sometime. We gotta get together because
you guys, it's so bad that I have a girlfriend. She's amazing, and she's a criminal defense attorney. She has sat down in front of me and said, I would much rather defend a convicted child molester than ever step a foot into family court.
All of the good attorneys. all of the good attorneys go to other areas of law because
Don't say that, Megan.
Because, well, not you. Very few people. My
I did
sister
one
family court.
divorce court case, and I said never, ever, 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 ever,
My
ever
sister
again.
did family court. It almost killed her. I mean, she had to stop doing it eventually because it was just it's so soul crushing.
It is soul sucking.
So the
really
fact
is.
that you continue to do it is amazing, Dani. You should be like lauded, and parades should be held in your honor because
stop.
attorneys but they go on to do different things that are easier, that are less troublesome because family court is so bad.
Oh, and the funniest thing is clients think that you should not get paid.
Oh, right.
They're always like,
Yeah.
wait, why are you charging me? And it's like, I'm sorry, what part of this process did I not
Okay.
explain well enough to you? But that's a whole nother discussion.
We're gonna leave the billing behind, and Givener says Dani is on the mission. Wait,
Yes.
what the? So that is a dinosaur with a tow missile launcher riding a shark flying above the ocean.
Fuck yes,
that
this
is an
person gets me.
That is an awesome profile picture, Givener. I never looked at that. I never saw that one close up. All right, let's go. Just a few more minutes and we're done.
Judicial proceedings.
Well, that brings me to the second incident in my remaining time before my friend Ms. Clark speaks for one of the amicus, which is that when he issued the pickup order, the judge had already made a determination that no party lived in Missouri, and he encouraged the mother to go to court in Utah. So this is a judge acknowledging with predicate factual findings that he lacked jurisdiction under the UCCJEA, and that statute is a jurisdictional statute. The whole point of it is to stop these sort of interstate squabbles over which court is properly.
Do Missouri courts agree with you that that's a jurisdictional statute?
Yes.
Missouri is in the minority of states that holds that the UCCJEA is not a subject matter jurisdictional statute, but that gets to the second point, which is judges' determination of subject matter jurisdiction is for actual cases and controversies before them. In Stump, there's a petition for sterilization before him. Here, there was no petition that would warrant a capias order, which is what this pickup order is. Those are normally issued in delinquency cases. There was no petition or motion for delinquency. In fact, the only thing before the court, which had already acknowledged it did not have jurisdiction, so the judge actually knew that he lacked jurisdiction, was a motion for contempt against the father. It does not follow from that a capias order to pick up the children and take them into custody would issue. I mean, and this court's own precedents in Birch and Schottel analyze the subject matter jurisdiction in terms of the matter before the court, the case or controversy, the petition before the court. In other words, subject matter jurisdiction is not sort of presupposed. It has to be conferred by the actual matter pending before the court, and that makes sense. There are precedents in the Missouri Supreme Court looking to a line of cases where courts of subject matter, even general jurisdiction, cannot sort of turn themselves into courts of inquiry and start adjudicating matters that are not actually before the court on proper petition or motion.
But sometimes.
So, I mean, that's a very, very lengthy way of saying he can't do what he did because nobody asked him to do it.
And he didn't have any order. There was no written order by it. He just was doing whatever he wanted. And that's not how this works. There's process involved.
He's being a fuckwit.
He did nothing within the bounds of his authority. He did everything outside of the bounds of his authority. Judges don't have unlimited authority to just do whatever they want. There's a process. There are, my sister pointed out, like, if there had been a motion of some kind, the judge doesn't get to just go, okay, yeah, I'm denying the motion, or yeah, I agree with the motion. Everyone has to be heard. And there were no hearings on this motion. There was no motion.
Jim asks, why was Missouri involved at all if nobody lived in Missouri? The mother filed the motion to amend the custody arrangements in Missouri and then promptly moved to Utah.
Actually, let me clear something up. It actually happened. It was filed. They all had moved from Branson, Missouri in 2009, including the mom. They had been out of Missouri for nearly a decade prior to the Missouri lawsuit being filed. So it should never have been taken up by a
But
Missouri
in the
court.
complaint, it said she was living in Missouri at the time she filed it in 2019, and then a couple of months later, she moved to Utah again. She moved around a lot. It seems
She
like.
moved around a lot, but they had been out of Missouri for almost 10 years, including her, according to my source, who's a good source.
But anyway, that's exactly what the appellate, damn it, the federal court judges are talking about here now. It is exactly that. He had no jurisdiction. He just by saying you should take this up with the Utah courts, he was admitting that he didn't have jurisdiction. That's the argument. Oh, we lost Dani again. And someone was asking why. Oh, let's clear all these off real quick here. If a judge is assaulted in his courtroom, is he allowed to fight back?
I would imagine, yes.
The bailiffs will probably shoot you. Wild Red 1905. If a judge, wait, did I just delete the wrong damn one? And I hope I didn't. I hope I didn't delete. If I didn't read your super chat, I deeply apologize. Furby Slayer says a government immunity begets corruption. It must end. You got to have a good line somewhere. I mean, you can't just say, "Oh, okay, I don't like the way this judge ruled, so I'm going to sue."
But there should be ways, though, that judicial immunity is too absolute. Okay, it's too, we've gone too far in the other direction. We need to come back to the middle. Also, I have some answers for the chat that we're asking about the Louisiana law enforcement and what has been done against them. Bart Rocket filed kidnapping and false imprisonment complaint with the Forsyth Police Department, but Amy refused to be interviewed by them, and they didn't do anything because of it. He also filed a professional standards complaint against him. They did nothing. They didn't even investigate it. And he filed a complaint with the Attorney General, and he did nothing, and he is now defending the judge. So just so you know. Yeah, lovely. Death says, I just showed up. Why is Dani in ninja mode? The same reason she's no longer here. Utah is in the middle of this gigantic blizzard. Her internet was shitty. Turning the camera on would have sucked all of her bandwidth out of the way, and she wouldn't even have been able to connect for that. So it was just a desperate attempt to remain on, but she got bumped out again. But she'll come back when she can. God, hopefully. She's a fantastic source. She is. Jeff. I adore her. I can't wait to find out more about her work. Yeah, that's why when I was reading this about children of divorce, mother living in Utah, Branson performers, family law, I went, hey, I know exactly someone who this case was made for. Yeah, exactly. She got all the bases covered. You should never tell your Branson stories. Legendary Racing says they should have hired subject matter jurisdiction expert Darrell Brooks. Exactly. And Megan, does Rob of Law and Lumber know of this case? I don't know. I don't think so. I haven't talked to him about it personally. All right, let's wrap up this guy's arguments.
Sometimes courts get it wrong. I mean, I'm sure this court has been reversed by the Supreme Court because we've exceeded our jurisdiction in some case over the last 120 years, but that's still a judicial function that we've exercised.
Correct, but I think the distinction is errors or maybe even excessive jurisdiction versus clear absence. I'm going to go back to Bradley, Your Honor, Judge Strauss, which is this is more like the probate judge hearing the criminal case. The probate matter here was the custody dispute. Issuing capious orders to seize children simply was not before him. And that's where that hypothetical is so important. Subject matter jurisdiction is analyzed within the context of the actual case or controversy pending before him. Finally, the judge does state this was a very unique situation. I have to differ. Custody disputes are routine throughout Missouri, the 8th Circuit, the nation, and we do not see horrific fact patterns like here. Thank you.
Thank you, Mr. Eastwood. Ms. Clark.
And now they just have a friend of the court brief where she just says, stop it. And that's kind of that's the main parts of the argument there. She basically just agrees with the with Bart Rocket's counsel and is adding their support to the argument. And Jim says, I'm really confused. I thought the kids were arrested in Louisiana. Yes. How are they talking about the courthouse in Missouri when they were arrested in Louisiana? Because the Missouri judge somehow convinced the police officers in Louisiana to arrest the kids. And the kids still didn't want to go to mom, so they threw them in juvie in Louisiana. And it's twice that they were jailed. Once in Missouri, underneath the courthouse of Judge Amy's court. And then the second time, he ordered them arrested in Louisiana and thrown in the juvie hall. Yeah, and so all of these questions are fucked up because you shouldn't have to be asking these questions.
Yeah.
Everybody's asking these questions. How did this happen?
By the way,
That's the gist
here's
of
an interesting little caveat to this. The same circuit court, the same day, was also hearing the Duggar appeal, Josh Duggar's appeal. So that the decisions that will be coming down any day now will include Josh Duggar's appeal. He's in prison for child pornography, and he's appealing and saying it wasn't his. It was some friend of his, apparently. That's his story. He's only serving 12 years. I can't believe they only put him away for 12 years, and I can't believe that he has the nerve to appeal it. But anyway, so that's also coming down, which is why it could be taking a while, because they heard several cases. And so it's the Duggar case is on this docket, and so is the Rocket case. You've got two celebrity cases that they're hearing right now. So that's interesting. So when the decision comes down, I will absolutely be online to talk about it, and hopefully have Bart Rocket on with me, because when the decision comes down, he will be able to talk. He's not able to talk right now to the press until that decision comes down.
Yeah, and we don't really have a time frame. They'll do it when they get around to doing it. And that's kind of how this ended, with the judges saying, "Yeah, we'll get back to you."
Yeah.
So clearly, unless they were just bluffing all of us, they are going to crush the judge.
So.
They're going to crush the judge. No chance he's getting immunity from these guys.
No way.
Whether they appeal it to the Supreme Court or
And
not.
then imagine how much more time it's going to take for this to go to trial. And yet it's been 2 years already, and it's still we don't have a trial. We don't get justice. This is not justice. Delay of justice is injustice. Okay. It is not justice to have delayed this family's chance at a trial for this long. And I got to tell you, I'm so disappointed in our justice system in America that it's come to this, that for one, you can't even get justice unless you have hundreds of thousands of dollars to spend. Or in Bart Rocket's case, he got some Hollywood sponsors, right? Some famous families who decided they'd had enough of this and they wanted to help and are helping him fund this case. And there are so many families in Missouri who are suffering right now, who don't have access to Hollywood royalty, who don't have access to any kind of funding for this. And they have cases, but they can't bring them against the state. This is wrong. And people are suffering. Families are being bankrupted by these people in family court. And it's going to continue until we have precedent that stops this from happening. And the only kind of precedent that I would like to see in this case is Judge Amy dragged out of that court in handcuffs and thrown in his own jail without his shoes and socks and held unlawfully. If I were that circuit court judge, I would have been like, I've heard enough. Bailiff, take this man into custody, take his shoes, take his socks, put him in a cold cell, keep him in detainment, in solitary confinement. And I'm doing it without authority, and I know it, but you're going to have to fight me in court for the next 3 years to get any justice. That's what we're going to do, because this is baloney that he gets away with this.
Yep.
Even if he has to face them in civil court and he has to pay some money, he still gets away with it. And that's ridiculous.
Well, Megan, like I said, when I saw the tweets, I thought, oh, that's interesting. Then I read the articles and I thought, oh, that's really kind of deep. And then I listened to these arguments and went, oh, that's kind of funny. And then I read the complaint and said, we're talking about this. That criminal complaint was completely insane. Not a criminal, the civil complaint was.
It should be a criminal complaint.
It should be. You're doing the Lord's work on this one, Megan.
Well, I've been working on these Missouri cases for years, you guys. I mean, and I've got so many suffering families. I've got drawers full of these victims, and none of them have seen any justice. This will be the first case. If he loses his bid for immunity, this will be the very first case out of Missouri that is going to get their day in court. Evita Tolu's case was dismissed all the way up to the Supreme Court. They dismissed it on the grounds that they said that the court-appointed psychologist and the court-appointed guardian ad litem got judicial immunity for her case. So the merits of her case were never heard in court, which is a crime, because the merits of her case are good. She has great evidence that these people colluded to take her children from her, to bankrupt her, and she's not going to get her day in court. This was the same case that 31 judges had to recuse themselves because they were caught colluding with guardians ad litem against a litigant in their own court. And that case is never going to see the day of the light of day. in Missouri. They have closed ranks in Missouri to make sure that none, and there are like 5 or 6 lawsuits against the same guardian ad litem, Elaine Pudlowski. It's a huge scandal, and every single one of them has been thrown out for immunity. She gets immunity. Doesn't matter what she does to families. It doesn't matter how she lies. It doesn't matter how she hides evidence from a judge of abuse or how many abusers she gives to kids to. She gets immunity. And this will be the very first case where somebody loses their immunity. I can't wait.
Surround the judge with booty goons. Exactly, Doge.
I don't know what that is. What's a booty? Oh, no, wait, don't tell me. I just figured it out.
No, I'll just tell you. Next time you're on a stream with Drex, ask him. That should tell you all you need to know.
Oh, no.
That should tell you all you need to know. But now, Dani, thank you so much for being here. You got snowed off the show. If you want to see more of Dani's videos and things, go to Dani Ahn Direct, her YouTube channel, Dani Ahn Direct, also on Twitter.
I'm gonna go
MeganFox.locals.com and Megan Fox Writer on YouTube. Not the thumbs, the writer. I got no words for this shit we talked about today. Just none.
Well, I'll keep you updated. I'll keep you updated on what happens when the decision comes down. We can maybe do another stream. We can talk about it because this case has got to be national news. And I'm shocked that I'm the only one really talking about it. I got to write an article soon. I got to get working on it so that I have it ready to go when the decision comes down. But you can read about that on pjmedia.com. You can find me there by clicking on columnists and then go to my name. You'll find all of my reporting. If you just Google PJ Media, Bart Rocket, you'll find 2 articles that I've already written about this. The first, complaint, the lawsuit, and then the first denial of immunity. And now there will be a third one. And again, Jeff has that link for my Missouri 27-part series on the family court corruption in Missouri, which is huge. I actually have decided I'm going to put all of those into a book, and I'll be publishing that soon. I'm going to start working on that. People have been asking me to do it, and I've just been procrastinating, but I'm going to do it now because I've got to do something. And I can't, the word needs to get out about what's happening. And maybe I'll work with Dani to get her to write a forward to what she's seen in family court.
In flux with the last super chat of the day. I seriously don't understand that there aren't more. Yeah. Yeah. What Flux said.
I have never understood it myself.
Totally disavow, by the way.
I disavow it, but I don't understand it. I still don't understand it.
Wow. That's there's no happy way to end this. There's no happy way out of this. Just MeganFox.locals.com, Megan Fox Writer on YouTube, Dani Ahn Direct, and please like me and subscribe to me. If you have already subscribed, make sure you're still subscribed. With that, let's shut down the like and subscribe poll. Let's see how we did. Did you hit the like button and make sure you are subscribed? 4th place with 9%. Yes, because you just mentioned it. With 10% in 3rd place. Yes, I cheated and did it, but then I went back and repented and actually, because we always have this. Somehow I have more people taking the like poll than have actually hit the like button. Weirdly, today we're at there's still 8 more people that voted than hit the like button. So cheaters. And in 2nd place, did you hit the like button and make sure you're subscribed? Yes, God, stop talking about it with 20% of the vote. And 62% of you said, yes, I always do. Thank you so much for that. The poll is over for today, which also means the show is over for today. What's going to happen now? We're going to wrap this up in about 30 seconds, and you're going to be automatically fed into Good Logic Joe for more of the lovely, amazingly wonderful, fascinating, enthralling and captivating Murdoch trial. I'll pop on over there on Joe's stream in a minute as soon as I kind of go to the bathroom and get a drink. I need some booze for that. Thanks, mods. You're being the best mods around. Chat, you're great as always. Those of you that were just being fuckwits and got themselves banned, I've banned more people tonight than I have in my entire YouTube career to this point. Y'all can go fuck yourself. Those of you that were mature adults, and you guys know where the line is. Thank you for keeping it in check. Chad asked about Linktree. Here comes the Linktree. Get ready to copy and paste Megan Fox's Linktree. Boom. I'm not important enough to have a Linktree. I'm here.
I just
And on
finally
Twitter.
figured that out, and it's actually a good idea because you can just get all your stuff and all your links in one place, which is great.
Yeah.
So
Mustang McCracken says, "Ban me, Daddy Jeff." Sorry, you didn't cross the. You didn't. We have two rules on this channel. That's it. Don't say anything that's going to be deplatformed, and don't shit on my guests while they're on my stream. That's it. That is literally it.
It
So,
doesn't
all right.
seem like it should be that hard to follow.
No, it's really not, is it? Let's go over to Good Logic. I'll be over there in a minute. Let him know he's just had a legal vices raid and that I shall join him in the very, very near future as soon as I get me a nice large glass of booze. All right, Megan, thank you so much for being here and for bringing
Thanks
this
for
to the
doing
attention.
this. Thanks for doing it because the Missouri stories need more attention, Jeff, and I'm really appreciative that you did.
And I know I said we'd run 15 minutes over, and we actually ran 90 minutes over. That's just because I talk too damn much. Here we are.
An important thing. It just is.
Megan, you're one of my ride or die people. Love you to death. We're going to do it again, regardless of what the chat says.
It was only about 5 idiots, really, to be completely honest about it. It's just 5 very dogged idiots.
And that's the final thing that I just wanted to say about that. It's amazing that 5 people can derail a chat of 1,300.
Yeah. And like
'Cause
most
they're
people are like, we have no idea what this is even about. Either do I really, but just so you know, I always pick up weird trolls eventually for one thing or another, because if you're doing the right thing, if you're doing good journalism, you're going to piss people off. That's just how it is. So I always have a trail of pissed off people following me, but usually they're in the minority. So just ignore, just move on.
And on that final note, that's Megan Fox's Jerry Springer's final thoughts. At the end of our little shit show here today.
Don't do that while I'm drinking coffee. I almost got it all over my computer.
As Major Frank Byrne said in one of my favorite MASH episodes of all time, it's nice to be nice to the nice.
It is nice.
Bye, y'all. Lorax out.